My pleasure. My lord, may I mention for listing tomorrow, my lord, one content matter, my lord. The long months back, my lord, the direction has been already expired. But I still, my lord, the respondent department and the Elise contemner is not complying still, my lord, order pass petition code. For other summa.
Yes. I'd like to mention the petition number 354/2024. This is a tender matter, madam. Madam, this matter is supposed to be listed after 2 weeks. That's more than 2 weeks not listed, madam. Tomorrow it is listed.
May pleasure, Lordship. I'd like to mention one unlisted IA in connection with petition number 292 of 2024.
What
And
is
it's an urgent matter.
What is the reason of filing?
This is
What is IA for?
eviction matter. As your Lordship has already observed and passed order, the eviction order is going to be terminated within few days. That's all.
Please, my lord. My lord, I beg to mention WPC 544 for withdrawal, my lord, tomorrow.
Well, also, I beg to mention item number 25.
Item
25. On behalf of Pitapok.
What is this IA for?
Condonation of delay. Senior is could not appear here because his uncle is expired.
No, it's still it's for condonation or delay. Just wait till the matter is called. It's only for condonation or delay. Let us see. Please wait.
Let's say posted for tomorrow.
No. Tomorrow we have already seen so many mentions. So you wait for your turn. We'll see when the record comes.
Yeah, Lordship, Lordship, I will mention item number 9926.
19.
Yes, 9926. I'm on behalf of Omodi.
You want an adjournment?
Yes, my lord.
You're taking consent?
Yes.
Okay. You're from?
For
Item 19, you're
19 respondent or respondent.
19 respondent. Okay.
Yes, ma'am.
With consent from the petitioner, the Land Council for the respondent place for adjournment is allowed. List after 2 weeks. Item 26, you are?
Petitioner, ma'am.
You are petitioner. Okay. Then on the prayer, both sides are represented on the prayer made by counsel for the petitioner. Matter stands adjourned today. List after 2 weeks.
My lordship, after 4 weeks.
4 weeks?
Yes.
Okay, 4 weeks.
Lordship, I beg to mention one WPC number 303 of 2024. It was listed on last Friday. It was supposed to be listed today. So regarding objection of one of order passed by the Supreme Court 2nd August 2024.
Okay.
Lordship.
Your Lordship, may I mention item number 33?
33.
The leading counsel for the respondent is on leave, and it's also reflected in the cost list.
Yes. What is your prayer on behalf of?
Subbu Koyang, the counsel for the respondent.
For the respondent.
Letter of absence is there. Letter of absence is there.
Okay. All sides are represented. In view of inability of the counsel for the private respondent to appear before the court today, the matter stands adjourned. List after 4 weeks.
My subline.
May I please, your lordship? It's an application under section 483 BNSS arising out of Duimung PS case number 71 of 2024. So my allegation is page number 14. It's an FIR. May I read, madam?
Page 14.
14, page 14.
When were you arrested?
It's an FIR.
When were you arrested?
Arrested on 15 of July 2024.
16 July.
Today 70 days.
Okay, this is fake note.
Yes.
Fake Indian currency.
Fake,
note.
yes,
Yes,
face currency.
currency, yeah.
You get
Punishment
you
is,
get the case
Punishment.
diary.
yes, your lordship. Call for the case
When?
diary. Your lordship.
When?
Yes, call for the case diary, your lordship.
When?
At this stage.
Your lordship, maybe on 3rd, your lordship. Maybe on 3rd of October, your lordship.
CD may be called for.
Third will be too late.
Your lordship, it's the statutory
Make it
period is
30.
90 days, your lordship.
Make it on 30, 30.
Okay, your lordship. Otherwise, your lordship, the statutory period is 90 days and end that is 70 days, your lordship.
No, we are not concerned with those. Even if he's in the jail for a day, he has a right to be considered for bail. Make it 30, 30, because
Okay.
this third will be too close to vacation. Both sides are represented. Let the case diary be produced on 30. Case diary or scanned copy thereof be produced on 30/9/2024. Also get a scanned copy.
You can copy it, your lordship.
Okay.
Deeply obliged.
May it please, your lordship. Your lordship,
Yes.
this is an anticipatory bail filed under section 438 of CRPC, your honor. Your lordship.
Where is the FIR?
Yes, your lordship. In connection with newly PS case number 40.
Where is the FIR? Which page?
Page number, the FIR is in page number 17, your lordship. Here, your lordship, the interesting
just
part
a
is, your lordship,
Just a
The-
moment. You arrested when? What is the date of your arrest?
no, your lordship, the accused person has not been arrested yet.
Oh, this is anticipatory bail.
Yes, your lordship.
Okay. Yes, Mr. Taro.
Offense was, FIR was lodged on 22nd July, after the coming into effect of the new law. He has invoked CRPC. It should be under new law.
Oh, that's okay, we'll have it corrected. But what do you say on merit?
It's a case of cheating. Case of cheating.
Huh?
It's a case of cheating. 420.
Your honor, your lordship, the police has charges under 417 and
Yes,
420 of.
You have, you're a hurry.
No,
You're in a hurry.
No, your.
Wait, I'm asking the
Yes.
ABB.
It be, let it be withdrawn and correct. Or
No, no,
amend.
we'll get those things corrected. For these small things, we don't send away a person.
Because
The ratio will do it. Only it has to be typographically corrected. But what on merit? cheating, no ingredient of cheating is there. It's a simple contract for money, lent. It's a civil dispute.
Investment and no return back.
Oh, those are civil disputes.
Yes, almost.
You see, when I was what do you call, in fact, yesterday, one of my known lawyers, he was telling me that no, days are bad. One of my client did not pay my fees. Correct. So even in fact, yesterday, somebody had called me, very old acquaintance from Calcutta. I think that these are very bad days. Clients did the client's work, but he did not pay.
Exactly.
Is it cheating?
Same we have in this case.
Is it cheating? Non-payment of money is not cheating. We'll grant him an interim. We call for the case diary. Mr.
In Kakum,
N. Kakum, learned counsel for the petitioner, as well as Mr. G. Taro, learned APP for the state. Next paragraph. At the outset, the preliminary objection of the learned APP is that the application is filed under section 438 CRPC, which is already repealed. So in the said context, the court is of the constitutional opinion that it's a rectifiable mistake, and therefore we direct the learned counsel for the petitioner to make necessary correction in the cause title of this pre-raise bail application before the registry under his signature. Full stop. On such correction being made, the central registry shall also be corrected. Next para. Next, petitioner was pending arrest in connection with Nirjuli PS case number 43 of 2024 under section 417/420 IPC is paying for pre-arrest bail. Next para. Let the case diary be produced on 30/9/2024. Next para. The learned counsel for the petitioner has prayed for interim bail, which is opposed by the learned APP on the ground that a clear case of cheating has been made out. Next para. Next para. From the FIR, it appears that the informant had advanced a loan to the petitioner so as to enable the informant to complete a contract. Sorry, the petitioner to complete a contract work. So thereafter, the petitioner is not traceable, for which the FIR is filed. Full stop. Yes. The agreement discloses a financial transaction between the parties, the court is inclined to grant interim pre-arrest bail to the petitioner, namely so and so, by providing that in the event of his arrest in connection with usually PS case number 43/2024 under section 417/420 IPC, the arresting officer shall release the petitioner on bail, interim bail on furnishing a bail bond of ₹50,000 with one surety of like amount to the satisfaction of the arresting authority. Full stop. The interim bail is granted on the following conditions. You take conditions from. There are conditions, huh? In one of the conditions, say the petitioner shall appear before the IO within 7 days from the date of this order, failing which this interim bail will not come in the way of the police to arrest the petitioner. Full stop. Accordingly, it is also provided that on appearance of the police of the petitioner before the IO, he would be given a acknowledgement of appearance. Next paragraph list on 39/2024. You do the corrections, otherwise your bail order would not be signed.
Yes, Your Lordship.
Today, take it, do whatever my courtmaster says, go and correct the cost title. Otherwise,
Yes,
the order will not be signed.
Yes, Your Lordship.
Obliged.
Deeply obliged.
Mayor Lordship. My lord,
Yes.
this is an application under 528 of the BNS for setting aside and quashing of the.
We'll call for the case diary here.
Your
It's
Lordship,
498A, right?
My lord, it is, proceeding is pending before the JMFC court at UPA. And next that is on 12/12/2024 for appearance of the accused person before the JMFC court.
Where is the FIR?
My lord will file FIR at page number 15.
Is the
Page number 15. My lord, may I?
just a moment. Yes.
Your Lordship, Your Lordship, I will only on this affidavit, page number 12, whether both the parties has jointly signed this affidavit or not, because both the names are there. So affidavit, whether they have come to file the respective affidavit or not in supporting of their petition, Your Lordship.
No, but this will grant an interim, but you see this page 27.
My lord, immediately after lodging the FIR, with the intervention of both the both the family.
Please stop for a moment. I'm interacting with the APB, right? You see this agreement?
Yes, your lordship.
So this police will have to say that they have received this copy. So we grant an interim.
Yes, your lordship.
Yes.
And TCR may be called for.
Yes.
Yes.
No, this will not be in TCR. It will be in the police report.
Your lordship, charge sheet already filed, your lordship. The trial commence, your lordship, perhaps. Trial commence, your lordship. Investigation part over, your lordship.
Oh, acha. Oh, they have applied for quashing. I thought this is a bail application. Okay.
Your lordship will find
Okay,
charge sheet in
okay.
page number 21 to
No, I
26.
wrongly read it. I thought it was a bail application.
Okay, your lordship.
Or Mr.
T. Sunil.
T.
Sunil.
Sunil, learned counsel for the petitioner. Also heard Mr. J. Sering, learned APP for the
Your
state.
lordship. T at the, your lordship.
Okay. T.
At the, your
Oh,
lordship.
T80, I'm sorry, extension, sorry. T80 learned APP for the state. Next para. By filing this criminal petition under section 528 of BNSS, the petitioners have prayed for quashing of Itanakar woman PS case number 5 of 2019, dated 31/1/2019, corresponding to GR number 55/2019 under section 498 capital A IPC, on the ground that the matter has been compromised and they are living together. For which the petitioners are relying on a deed of settlement dated 18th September 2024. Next para. Issue notice, returnable in 4 weeks. Extra copy of this application we give, this petition we given to the landed APP to enable him to obtain instructions. Next para, let a scan copy of the records of GR case number 55/2019, pending before the Court of Learned Judicial Magistrate First Class, Papumpare, UPR be requisitioned. To stop. The registry may send a requisition through email with liberty to the learned trial court to send the scanned copy of the LCR. Make it TCR, huh? TCR. By email for being produced before the court. Next paragraph. Till the next date of listing, the proceedings of GR case number 55/2019 under section 498 capital A IPC, pending before the Court of Learned Judicial Magistrate First Class, Papumpare, UPR, shall remain stayed. Next paragraph. The petitioner shall produce a certified copy of this order before the learned trial court to bring the order to its notice. Next paragraph, this start. 4 weeks give a date.
Problem.
Master Press.
Yeah, please, my lord. My lord, this is for the passing of the criminal proceedings pending before the Colorian PS case, Colorian Judicial Magistrate, my lord. Here the petitioner number 1 and 2.
But this is not a matter which can be quashed.
My lord, they settled the matter, my lord. And
You see, it's a case where you had voted on behalf of another.
my lord,
It's a electoral offense. Electoral offense can't be compromised between two parties.
my lord, the complainants appear before the judicial magistrate first class after settlements,
It's an
and they
electoral offense.
deposed also, my lord. She agreed.
In trial, you may get acquitted, but the problem is that in cases where you are misrepresented and given, you have voted, it's an electoral offense.
My lord, offense is not so grave, my lord. Offense is punishable. 171F is punishable.
Even if it is punishable for 100 rupees, still you can't do it.
My lord, may I kindly see the depositions of the informants, my lord.
I can't adjudicate, you see, because it's an offense against the state.
Man,
It's not a private.
even trial continue also, my lord. It will brutal exercise of the trial court, my lord.
That we don't know. That we don't know. But an electoral offense can't be compromised like that. It's not a compoundable offense.
Yes, it's not compatible. Man, they have settled the matter. They are the niece and uncle, my lord. Both are related, my lords.
No, if you can get it, if you can get an acquittal there, we can't have any grievance. But it has to be by way of a trial. Electoral offense can't be compromised like that. They're not satisfied even to issue a notice.
My lord. Then, my lord, proceeding till returnable death. Next date is fixed on 17th of next month, my lord. For further evidence, my lord. Depositions of the petitioner number 2 is clear says she consent. She had consent. She had authorized, my lord. In her deposition itself, my lord.
No, you see, we are of the view that if it's an electoral offense, you can't even issue a notice. So you can have it settled in the court if you can. But it's not a case of quashing. Electoral offense can't be quashed. He cannot go and cast on behalf of B.
My lord, on authorizations,
By authorization, even you can't buy authorization. Even the God's will not be enough.
and authority, then
Even if the God himself comes and says, please allow somebody else to vote. Even that cannot be allowed.
the officials, authority itself has accepted the authority letter, my lord.
Sorry, we'll be dismissing your application.
This is the my lord, then notice may be issued, my lord.
Notice, no, I'm dismissing it. Question of notice does not come. You satisfy me that in misrepresentation, somebody else can go and vote.
No, my lord, here petitioner number 2 says she did not vote, but on her behalf, she did not say the petitioner number 1 had voted.
We are not concerned with that. What happens in the trial is not the concern. Right now, the concern is whether somebody else can go and vote.
FIR, can see the FIR also, my lord. In
No,
FIR,
we are not.
she only
we're
says
not
that
interested.
she did not consent her to
We are
take
not
the
interested.
total ballot, my lord.
We are not interested. You see, there's an FIR.
Yes,
It just says one line. I saw a dead body on the road. That is the only one line FIR lodged before the police station.
my lord. Here, my lord.
Police FIR should not be encyclopedic.
Offense is, my lord, against the
Against the state.
in nature of the private, my lord.
Against the state.
No, my lord. It's
Electoral
against the
offense is an offense
right
against
of
the
the
state.
right of the petitioner number 2, my lord.
Oh, then we pass an order. You just challenge that order in an appropriate way.
Well, then,
Postal ballot, you can't just impersonate and vote. It's a major offense against the democracy.
my lord, that's true, my lord. But in respect of voting,
No,
my
no.
lord,
I'm sorry, I'm dismissing it. Heard Mr.
Catering, my lord.
K. Tari, learned counsel for the petitioner. Also heard Mr. G. Taro, learned APP for the state. Next, by filing this application under section 528 of BNSS, the petitioners have prayed for setting aside and quashing of
Koloriang, my lord.
Koloriang, KOLORIANG, PS case number 28/2019, corresponding to GR number 24 of 2022 under section 465, 468, 471, 474, 171 dash capital F IPC, which is pending for disposal before the court of learned judicial magistrate first class Koloriang, Kurung Kame district. On the ground that there has been an amicable settlement between the accused and the informant, by settlement dated 30/8/2024. Next paragraph. As per the FIR, which is lodged by the petitioner number 2, namely Miss Ibu HIBU, Kanku KANKU, the petitioner, namely Kago KAGO, Dibo NIBO, had taken her postal ballot from DEO office, Kureng Kumed, Kolodiang, on 8/5/2019 without her consent. To stop, she has alleged that a false authorization letter was submitted by the petitioner number 1 with her forged signature. Full stop. Full stop. On receipt of the said FIR dated 15/5/2019, the hearing before referred case has been registered. Next paragraph. The learned counsel for the petitioner has referred to the statement of the petitioner number 2 dash informant as PW1, and it is submitted that the evidence of the PW1 would not be sufficient to convict the petitioner number 1. Moreover, it is submitted that as there has been an agreement on 30/8/2024 between the petitioner number 1 and the petitioner number 2, there is a very bleak chance of conviction. Next paragraph. Heard the learned APP in the matter. Next paragraph. The court is of the considered opinion that and electoral offense. It goes to the root of democracy, cannot be allowed to be, cannot be quashed, as this is an offense against the state and no longer remains a private dispute between two sides. Full stop. Therefore, command. Notwithstanding the settlement of the dispute between the petitioners, comma, the court is not inclined to quash the FIR which is registered as Colorian PS case number 28 of 2019, corresponding to GR number 24 of 2022, under section 465, 468, 471, 474, and 171F IPC. Full stop. Accordingly, this petition stands dismissed. Criminal petition stands dismissed as a motion stage without issuance of notice on the respondents. Yes, where is the FIR?
Yes, Mayor Lordship. Yes, Lordship, this application file under section,
Where is the
What?
FIR?
yes, FIR number, this is page number 15 to 17, Lordship. 15 to 17 page number. Yes, FIR is that against unknown couples, young couples. Understand the owner of the Amer restaurant Nudes Market that in the evening hour 21 August 2024 at 8 p.m. around, one known couple have came to my restaurant and served us per their choice. While serving, the said young couples begins livestock kissing and hugging each other. Then my daughter-in-law approached them not to do such thing in this place, for this is a family restaurant. And then a boy warned them and stood up, assault them. Afterward, they pushed her chest and punched her face and physical assault her. Then I came to finding the fact, but he didn't willing to me interference. And he also punched me in my face, broke my eyeglass and close too. And he warned me, Adi galo sala tumko yaha dapna dega. Then my wife came out from the room and then he beaten my wife also. Then after many have come, then the couple had called many friends and situation became worse. Then police came and handled the matter with face. While the police escort on the roadway to the police station, then one elderly had warned me to chopping my other hand too. So this is matter of criminal implementation and risk of future for my intervention is need here to trace the person who warned me unparliamentary. Therefore, sir, you are good officer to register my affair against the above unknown person as the relevant role. Yeah, your lordship, this is the affair, the laws by this petition number 1 against the petition number 3. Then after lordship, the lodging the affair, the case was registered before the Papu Hill police station. And the case was registered on 21 August 2024. Then after lordship, the board parties, the petition number 1, 2, and 3, they called for a local kebang nail at North Village. Then after the board party has settled the matter mutually on the 8th September 2024. Now,
Lordship, my prayer before this honorable court that the case is pending before the police station for the investigation. The matter has already settled by the both the parties, and it is not necessary to continue the police proceeding, Lordship. And my prayer, the interim order may pass that the investigation part of this case may be stay or suspend till the dispose of this petition, Lordship.
You see, one extra line here and there changes the entire perspective. You say that there was a local kabang.
Yes, Lordship.
Where is that kabang decision?
Yes, Lordship, this is the page number 18 to 19. This is the deed to mutual settlement by the both the parties, the victim and the accused person.
Is this kabang decision? Is 18 and 19 a kabang decision?
Yes, Lordship.
Please read that. Please find out the kabang.
Yes, Lordship.
Reference to kabang.
Deed of settlement is made on 8th of September 2024, Lordship.
You have heard us. Just
Yes.
find out the word kabang decision
Yes.
here.
The fact of the case that on the 21 day of August 2020, some couples were kissing each other inside the restaurant of the past party, owing to that the brother-in-law of the past party.
You have heard us.
Yes.
Have you heard and understood what the court is asking to you to do?
Okay.
Did you hear us?
Yes, this term and conditions of this kabang, Lordship.
Or if you don't listen, then we adjourn the matter. Come prepared tomorrow. The learned counsel for the petitioner
Lordship, this is
not prepared in the matter. List the matter tomorrow. But this tomorrow is tomorrow. 24. List on 24. Please understand first and then make submissions. You have.
Lordship,
Please don't test the patience. If you have not understood, you should say I have not understood. But you shouldn't proceed. Don't test the patience.
Lordship, only this.
Don't test the patience.
Sorry, Lordship.
Tomorrow, make it tomorrow. Just say Mr. Ete, then APP is present.
Much obliged.
Please be attentive. Court is asking you a question for the third time. It is after third time that I have expressed my annoyance. If for 3 times, if you don't understand, I have expressed the annoyance. Please try to understand when the court is putting your questions. Yes, next item.
Lordship, this is the same case in a connection with this.
Same.
Yes.
Then tomorrow. List on
7 also.
24. Huh? Same.
Much obliged.
Lordship, I'm the petitioner for item number 8.
Yes.
My
And
lord,
the-
this matter connected with item number 17, your lordship. The orders matter today, the matter is listed,
Yes.
this, Rajendra Kumar
Uh,
Lahoti. This
Lord-
matter is connected with that matter. Your lord.
Okay.
Lordship, I'm appearing in person. I'm the petitioner for number 8 and respondent for number 17.
Okay, we'll take it together after some time.
My lord, I have something to say.
We'll
you
take
would
it after
be
some
kind-
time.
If you would be kind enough. Okay, my
We'll
lord.
take it after some time, both the matters together.
Okay, my lord.
Obliged, your lord.
May I please, your lordship?
Yes.
This is the second round of litigation, your lordship. Earlier, at the motion stage, your lordship has disposed of the writ petition with a direction to the respondent authority to dispose of the representation of the petitioner within a period of 10 days. Till then, the impugn transfer order was suspended, your lordship.
Yes, where is that order? Where is that order?
Lordship. That is 43.
Oh, yes.
So, sorry, this is a speaking order.
Yes.
Thereafter,
Now, what has happened thereafter?
Your lordship, on the basis of the direction passed by this honorable court, and a speaking order was passed, which I have annexed at page 43, your lordship.
Page number
43.
43.
Annexure 8
Yes.
to the petition. This is the speaking order, Your Lordship. Order was submitted on 18. The speaking order was passed on the next day itself, Your Lordship, 19 September 2024, without considering the grievances in the representation. Across, may I read, Your Lordship?
Yes.
Whereas across transfer and posting of engineer Tar Hache, EE Sepa UD division and engineer Hilang Taju, EE Raga UD division was issued white government order number so-and-so dated 7/9/2024. And whereas engineer Tar Hache, executive engineer Sepa UD division has been challenged the impugn order dated 7/9/24 before the Honorable High Court, Itanagar bench in WPC number so got stay on 16/9/2024. And whereas the Honorable Court, while disposing of the said writ petition, has directed the respondent authority to consider and dispose of the representation dated 3/9/24 submitted by the petitioner on 10/9/24 by a speaking order. And whereas engineer Taju, though an AE was, may not kindly be noted, Your Lordship. And whereas engineer Hilang Taju, though an assistant engineer, was already functioning as EE Raga UD division in his own pay scale. And whereas such interim arrangements have been made in a few other districts due to administrative agency. And whereas as per service record, Tar Hache was posted at executive engineer Sepa UD division on 8/6/2018 and has already completed more than 6 years as EE Sepa division, Your Lordship. Therefore, in view of the above, the representation filed by Tar Hache holds no ground and the transfer and posting order in respect of Shri Tar Hache EE Sepa UD division and Hilang Taju EE Raga UD division issued white government order number so-and-so dated 7/9/24 stands remains valid, which is within the prerogative of the state government. This is speaking
But
order.
Mr. Singh, now we can't interfere with your transfer order because of their disclosure that you have been in the same place for 6 years.
Lordship, that is there, Your Lordship. That I have never disputed, Your Lordship.
No, it's
I'm
not a question of dispute. It's a question of after 6 years, when they are expressing the administrative exigency, that has to give way for.
Lordship, this is
your
not an
transfer.
administrative agency. I'll show on the face of record, Your Lordship.
No, but you have completed 6 years. You can't overstay in the same place of posting more than the prescribed time. You
Lordship,
see, you had a liver transplant. You were given your liver transplant, right?
Lordship.
So after that, you have been given this place you have been in the same place for 6 years. They have shown complaisance. But now you can't have an extended stay for whatever reason. And in this state, there are not one, but many departments where the juniors are holding higher posts for reasons best known to the government. They are not holding DPC. They are not promoting people. They are all
Lordship, basically,
ad hoc charge.
basically, Your Lordship, I am on the basis of the note issued by the Honorable Home Minister, who is not at all connected with the present.
Oh, there are, we can't help those things.
Kindly. Lordship,
We
kindly
can't help
come to
those
the
things.
note.
Even the Supreme Court recognizes right of a public representative to issue
Lordship,
requests.
that is true, Your Lord. At page 25 is the note, Your Lordship. May I read, Your Lordship, some. This is regarding transfer and posting
You
of.
see, even if this note is absolutely bad, but you have stayed there for 6 years, you can't remain there merely because the note is bad.
And on the below, the file was also, as it's also written here, that as discussed, compile all such requests, examine and put up a consolidated transfer posting under in consultation with.
Let me ask you in a different way. You see, you are all I'm just giving a very horrible example. I'm good in giving horrible examples. So this is one. You see, I'm here for now so this is my second week I'm here. All of you are fed up with me. Some few people of the bar says that, well, we are fed up, 2 weeks he is there. So please send somebody else from the principal seat to here. Let us say it happens. So you are, but no, I'm not on that. You see, number one, Lords will still have a right to give representation. We can't stop that. I may not like it, but still you have a right to representation.
Lordship.
You have given it. And then it's the prerogative of the Honorable Chief Justice to post somebody, whether you like it or not here. Same thing for the public representatives. They find that you are there for 6 years. They now say that please send him, this is a good man. What is so wrong about it? Even if this the departmental note by Home Minister is bad.
Lordship may kindly kindly appreciate that whether the interim transfer order was issued in the public interest or just to accommodate the private respondent, Your Lordship. There is also one part, Your Lordship. And the person who have been transferred in my place is not at all executive in Your Lordship. In view of the judgment, in view of the law laid down in Hibu Damas case, Your Lordship. In Hibu Damas case, which I have brought, Your Lordship.
Then it will upset the entire administration in the state of Arunachal
Lordship,
Pradesh. Here,
entire-
everybody is an ad hoc appointee in higher posts.
The entire, this judgment is covered, Your Lordship, with this case, Your Lordship. I would like to altogether, all observations, whatever made herein, are almost similar to the present case, Your Lordship.
Yes. This paragraph.
Paragraph 49, 53, 62, and 63, Your Lordship. Here also in similar way. May I read, Your Lordship, paragraph 49?
Just give me 2 minutes. Yes, please.
Lordship. Paragraph 49, Your Lordship.
49.
Yes. From a perusal of the order dated 7/6/2018, referred to herein above, which has been annexed as Annexure 8 to the writ petition, it appears that the respondent number 2 was allowed to temporarily look after the charge of superintendent engineer in his own scale of pay as stopgap arrangement subject to the following terms and conditions. The look after charge is made purely on temporary basis due to exigency of work in the department. The look after charge shall not consider on him any right to claim continuation and seniority in the post unless his service is regularized by duly constituted GPC as per the provision of recruitment rules attached to the post. The look after charge shall be terminated at any time without assigning any reasons and notice. Then paragraph 53, Your Lordship.
Yes.
The respondent number 2 on the other hand, is an executive engineer holding the substantive post of executive engineer, drawing the scale of pay attached to the executive engineer, but as a stopgap arrangement allowed to look after the charge of superintendent engineer on purely temporary basis, and for that purpose brought the office of the chief engineer RWD Eastern Zone only other day, wide order dated 7/6/18 to look after the charge of SSW in exigency of works in the department. The petitioner and the respondent number 2 therefore are not similarly placed officials in the department vested with the same status and position. Then, Your Lordship, para 62, Your Lordship. There is no quarrel with the proposition of law laid down by the Honorable Supreme Court in Rajendra Singh Supra that it is not within the domain of the High Court to enter into the relative inter se merit, conduct and integrity of the employees, which are within the exclusive domain of the employer. In instant case like WPC number 257 AP 2016, the relative merit, capability, conduct and integrity of the petitioner vis-a-vis the respondent number 2 have not at all been examined by this court. What has been examined here is the position and status of the petitioner, and the respondent number 2 occupies in the department to find out the correctness of inter se transfer made. On examination of the position and status of the petitioner and the respondent number 2 in the department, it is found that the petitioner and the respondent number 2 are not similarly placed officers, Your Lordship. This is important, Lordship. In the department, the petitioner enjoys the position and status, including pay and allowances attached to superintendent engineer, whereas the respondent number 2 have only been allowed to look after the work of superintendent engineer in the office of the chief engineer. Eastern Zone on purely temporary basis as a stopgap arrangement in the administrative agency of the department in its whole scale of pay of executive, which is substantial post of the respondent number 2. Then para 63, for the reasons and discussions made herein above, I am in respectful agreement with the law laid down by the learned single judge of this court in WPC number 257 AP 2016, and therefore of the considered view that the petitioner and the respondent number 2 being not similarly placed officers in the department, there cannot be inter se transfer between the petitioner and the respondent number 2, and the impugn order dated 29.
Yes, Mr. Navam,
Cannot be legally
there's a
sustained.
law laid down by this court.
My lord, I'll try my best to distinguish, my lord, based on the facts, my lord.
Yes.
As Lordship is ever in Mahmood Ahmed case, that Honorable Supreme Court has says, my lord,
This.
mainly because, my lord, there is a notice issued by the MPC MLA that will not be said the.
But that has been considered in this case.
But the facts are little bit different, my lord. What happened in Tama case, my lord, that belongs to RW department, wherein my lord, regular cadre is available. But the private respondent who was working as SSW, which is equivalent to, my lord, superintendent engineer, but he was not working in field, my lord. He was working in office. But here is the case, both, my lord, transfer, they are working in field, my lord. That makes the matter difference.
But unequal, this law has been laid down here. It says that there cannot be inter se transfer between the unequals.
My lord, the another issue, my lord, here, it is not the case of the petitioner that he is not eligible to hold as per the rules, what they are saying, my lord. Now, as per the recruitment rules, I think 2014, right? 13 or 14, my lord. My lord, the length of qualifying service is 5 years, my lord. Whereas, my lord, private respondent, my lord, here render more than 10 years.
Then your state should do a DPC and give him the full status.
Yes, my lord. Why? The another reason is, my lord, there are, my lord, multiple cases pending for lordship, my lord. That is insert seniority, my lord. Because of that is one of the reasons, my lord, why DPC could not be, my lord, conducted, my lord. Now, my lord, this entire department is a new department, my lord. The total strength of executive engineer, my lord, 33. Now we have 28, my lord, state. I'm sorry, district headquarters, my lord. Now, out of this, my lord, 33, only maximum like 10 are regular executive engineers. Rest are all officiating, ad hoc, in charge, look after, my lord. This is the situation, my lord. Not like with hemodava case, my lord. In hemodava case, my lord, regular, my lord, SU are available, my lord. They could have intercept change, could have made easily, my lord. You lordship must have seen in the, my lord, transfer order also. This is not only loan, my lord, transfer order. Your lordship will kindly see, my lord. There are other, my lord, insurers also, my lord, who have been transferred, my lord. If your lordship see the.
Lordship, they have not come up before this on it. Lordship, sorry, sir.
No, these are the matter of the fact, my lord. I am basing on the record placed by you only. The transfer order, my if your lordship see, my lord, number one itself is in charge, my lord. As your lordship seen, my lord, number one, my lord. Lewang Osai, executive engineer IC means in charge, my lord. Same as my lord, private respondent number 2, my lord. Here also serial number 2. Hilang Tajo, my lord. Executive engineer IC. So petitioner case is not the only, my lord, loan issues, my lord. As I've said, my lord, there are only few regular executive engineers, my lord. Maximum 8 or 10, my lord. The total is 33, my lord. Now capital has been managed by, my lord, 5 executive engineers, my lord, including the, my lord, that smart city, my lord. The chief engineers, my lord.
But how do you take away this, the
My lord, facts are
effect of this order? Hibu Tama.
Yes, my lord, I've gone through it, my lord. Facts are slightly different, my lord. If your lordship see, my lord, the ratio laid down in Mansud Ahmed case, my lord.
That has been dealt with here.
That was
Yes,
Point of 11.
yes. And if your lordship see the facts of the Himutama and present case, totally different, my lord. The another issue, my lord, which my friend has not appraised in this honorable court, my lord, he has been already released from the, my lord, division, my lord. This case was filed on, my lord, when did you file? 21. My lord, he has been already released, my lord. I have this copy, my
No,
lord.
you see, there is a difficulty here. In this decision, but you have a copy of this.
Yes.
Please give it to the additional advocate general.
Himutama. This is Himutama.
You have it?
Yes.
Okay. Please come to page 515.
I'm sorry, 5?
15.
5-1. Yes, ma'am.
There's a reference to
Godabaran, my lord.
this Janardhan Devnath case,
Yes,
serial
ma'am.
number 2,
Yes, ma'am.
FR 15.
Yes, ma'am.
Now this FR 15, you come to next page. There's a reference to 14B. Last left side column, page 516.
Refers
Last
to
14 capital B.
15.
Page 516.
516, right, my lord?
Extremely down.
Left side, my lord.
Extremely down, left.
Extreme down.
14B.
14B. 14B, yes, ma'am.
Subject to provisions of 15 president transfer to another post of the same cadre, the lien of so and so. Therefore, it will be transferred in the same cadre.
Same cadre, my understanding, my lord, that is the same cadre, but executive engineer. Be it be regular or officiating, my lord. It did not say, my lord, it should be regular, my lord. Here it didn't say, my lord, regular, my lord. It says only cadre, my lord. So, my understanding, my lord, cadre, even the in charge also, my lord, it will be carrying, since he's discharging the duty of the
But
executive
its
engineer, my lord.
substantive post will be lower. So,
So it does not say, my lord, it should be regular cadre, my lord. Here, my, it does not say it should be regular cadre.
Regular, and we don't understand that concept. If somebody is in charge,
My lord.
he will still be holding in the cadre of the substantive post. He can't join the cadre of executive engineer. We are unable to accept that.
But he will be discharging
will
the same function, my lord. He will be discharging the same function, my lord, as executive engineer. Full-fledged, my lord. Only, my lord, the state as a pay class not given. But rest of, my lord, he's doing everything, my lord. The DD power, my lord, he is giving, my lord.
No, DD power, you can give it to even a peon. Drawing a disbursement officer does not require much anything. You see, but if his substantive post, you see, as per the decision of this Sibu Tama,
My lord.
He's being transferred against an executive engineer.
No,
And
my
in charge will not enter the cadre.
Your lordship referring to Hibu Tama, my lord?
Yes, I'm referring to Hibutama.
Yeah, my superintendent engineer, my lord.
Yes.
My lord.
In this case, page 24, you are saying as his executive engineer in charge,
Yes, my lord.
but an in charge can't enter into the cadre. He's not an executive engineer.
My lord. Agreed, my lord. He's not holding the regular cadre post, my lord. Yes, my lord. But if you see the, my lord, previous order, my lord, the first order, wherein the private respondent has been allowed to hold, my lord, it says, my lord,
Which page?
my lord, page 26 of the writ petition, my lord.
Yes.
26. Is correct. Yes, my lord. Has your lordship got it, my lord?
Yes.
It's an order dated 22nd May 2023, my lord.
Yes, he's an executive engineer.
Yes, studying, my lord. In the interest of public service, the governor of Arunachal Pradesh is pleased to order the following assistant engineers to hold the post of executive engineer in their pay scale. To hold the post, my lord. Your lordship will find the private respondent serial number 8, my lord.
You were seeing that?
Yes.
A.
8.
Hereafter, your lordship, in charge.
Please don't interfere. Advocate General has precedence.
This how, my lord, he has been allowed. This is the first, my lord, order allowing the private respondent to hold the post, my lord. And this was a, my lord, newly created division, my lord. My lord, why the petitioner, my lord, may kindly note, my lord, petitioner has not been demoted, my lord. He has been allowed to hold same field, but in different places, my lord. He's holding the same post, my lord, same position, my lord.
No, you transfer him against an executive engineer. Don't transfer him against.
No, my lord, not against assistant engineer, against my lord, executive engineer, because vacancy post is there. It's a field post, my lord. Raga, newly created division, my lord. And his expertise will be more required there, my lord, to develop the division, my lord. It's a newly created division, my lord. And he has only waited more than 6 years.
In terms of this judgment,
my lord.
You don't transfer him against executive engineer. Transfer him against an executive engineer.
In
See, this judgment is to be followed. You can't transfer him against a.
My lord, I'm sorry, my lord. In Hebu Tama case, my lord, the major difference is, my lord, one is field officer, one is a non-field officer. Because ASW, my lord, SSW is non-field officer, my lord. He works in the chief engineer office, my lord. Not independent like the, my lord, executive or superintendent.
No, this is referring to a cadre. It doesn't stay to a field post or a non-field post.
My lord, every, my lord, superintendent engineer, there are zonal division is there, my lord. If any superintendent engineer is posted in a zonal division, it's a field post, my lord. If he works in the SSW, then it's
That's
a
not
non-field
what I'm
post.
saying. You see, from this judgment,
My lord.
We don't find a class distinction in a same cadre on the ground that one is a field post, one is not.
Lord, may I kindly see the facts, my lord. My lord, the Himutava, he was working as a regular security engineer. The private respondent, he was working as SSW, my lord. Not a field post, my lord, SSW, my lord. That is also difference, my lord. And in that, my lord, the seniority has been settled, my lord. Here is the case, my lord, seniority is not yet settled because of litigation, my lord. It's not that, my lord, the private respondent is not qualified as per the recruitment rules, my lord.
No,
He's already crossed more than 10 years, my
You
lord.
see this judgment, you try to show us that the High Court, while deciding this matter, Hibutama,
My lord.
had found out the distinction between the field post and non-field post.
My lord.
This is something which I am not finding. You may be right. You're not saying you're wrong. You may be 100% right. But the decision of this court is not based on the field and non-field.
But when you see the ratio laid down by the Masood Ahmed case, 2007, it says every facts of the case has to be seen. It depends on the case to case basis. There cannot be straight jacket formula. It depends on case to case basis. I think that was also referred in this case.
No, you just have to show us, you see, you just have to show us
My lord.
that this man, this Healing Taju,
Yes, ma'am.
he is drawing a substantive salary of a post of executive engineer. You just have to show that. Because if you can show that he is drawing a regular salary of a executive engineer, then this.
My lord, as per recruitment rules 2040, the qualifying length of service from the feather post, this is the assistant engineer, to the executive engineer is 5 years. And as per our records, he has rendered more than 10 years.
No,
So
10, 15.
that way, he qualifies for that post, as per rules.
Having a qualification and drawing a substantive salary different, because in this case, Hibutama,
My lord.
that is one of the consideration that the person who was sought to be, who was being dislodged,
My lord.
he was not drawing the salary of superintending engineer. He was
Well,
drawing the salary of an executive engineer. That is
well,
one of the consideration.
My lord.
If I read this Hibutama correctly. So here also you have to demonstrate that this Healing Taju, who is an executive engineer in charge,
My lord.
is drawing a substantive salary of the post.
But when
Unless you are unable to show that,
My lord.
you can't find distinction between this.
May I put it like this, my lord? 2023, the private respondent was given, my lord, allowed to hold the post of executive engineer. There was no grievances from the petitioner, my lord. Right, my lord? So till 2023, he was holding the post of my executive engineer. Be it be in charge, my lord. Be it be in charge, my lord.
No, once he's not drawing a salary of executive engineer, he's still a junior and he fits into this case of Hibutama.
Salary
petitioner
perhaps,
is-
my lord, because of, my lord, non-finalization of the interseniority, my lord, because of multiple cases.
You have to stay.
That is one more point. The second point, as I've said, my lord, you will see the facts, my lord, both Hibutama case and here, my lord. In Hibutama case, my lord, the private respondent was not holding the field post, my lord. And here is the case, both are holding the field post, my lord. That makes the major difference. And third point is, my lord, the petitioner has not been downgraded. He has been given the same post, my lord, same field post, my lord, same status, my lord. So he cannot have any grievances. The third point, my lord, he's already rendered more than 6 years. In previous petition, my lord, that fact was, my lord, misleaded, saying that he has completed 1 year and 5 months, my lord. Of course, I have not.
2 years, 5 months.
No, that.
2 year, 5 months. Hibutama is 2 year, 5 months.
No, my lord, both cases, my lord, they have completed the length of service, length of, my lord, period, my lord. And here is, my lord, 6 years, my lord. Now he cannot say because of that injured, my lord, that he should be allowed to continue there.
You ask your instructing counsel to find out if he's not right, if this page 24, serial number 2, if
Yes.
he's not drawing the salary of a executive engineer.
My lord, I'll
whether
be
he's
very
drawing or
fair to
not.
this court, my lord, he is not, my lord.
He's not.
Yes, I'll be very fair to that, my lord. He is not, my lord. The order itself says, my lord, on pay scale. So drawing of, my lord, executive engineer pay scale does not say anything. But leaving aside that, my lord, not only private respondent, my lord, if you lordship see, my lord, the number 1, my lord, these two gentlemen, my lord, they are also in charge, my lord. They are also not allowed to draw the pay scale of executive engineer, my lord.
Yes, Mr. Singh.
Now question
Sure.
comes, my lord, how he is agreed because of that transfer of that. He has been not downgraded, man. And he has completed more than 6 years, man. Now he cannot say that he should be remain there forever, man.
Same thing here. He was also not downgraded, but still the High Court
No,
interfered.
there, my lord, he has just completed 2 and something years only.
2 years, 5 months.
Yes, man. But here is 6 years more.
Lordship, thereafter, after Hibutama's case, there were many writ petitions filed, Your Lordship, on similar footing, Your Lordship. Almost all of them were set aside and quashed.
My lord, this is the release order, my lord. We have to release order.
Finally,
I can give one copy to you also, no problem.
I will come into the release order, Your Lordship. On 20th,
Yes,
in regard to release order, Your Lordship, this honorable court has passed the order on 16, Your Lordship. The certified copy was.
oh, that's okay. Well, you are trying to
Well-
say something.
Lordship.
You are trying to say something that there are many judgments of this court.
Yes, I'm producing, Lordship. Producing. This is in respect of district fishery officer, Your Lordship. I'll show more also, Lordship. There are two orders. Initially, it was state. Initially, it was a state relying on the judgment of Hebutama versus state of AP. As because both the petitioner and the respondent were not similarly situated. No, I don't have. Yes, yes. And then next order I have given your lordship. In the said next order, it was set aside, your lordship. Order date in 19/1/23, lordship got it. Last paragraph, your lordship. In support of the condition, the facts are also almost similar, your lordship. As because the private respondent was, his substantive post was extension officer and the petitioner was district fishery officer. Raised by the petitioner, reliance has been placed on the decision of this court rendered in Hibutama versus state of AP and another, reported in 2020 for GLT 503. Lordship, in affidavit opposition filed by the state respondent, in the case also, the state has also filed their affidavit. Respondent number 6 is only an in charge GFDO. Respondent was posted at Hawaii, Anjo district, and his substantial post is extension officer in the Department of Fisheries, Government of Arunachal Pradesh, has not been denied or disputed by the state respondent. Since the contention raised by the petitioner that respondent number 6 is not a regular DFDO, but only an in charge DFDO posted at Hawaii, Anjo district, and his substantial post is extension officer in the Department of Fisheries, Government of Arunachal Pradesh, has not been denied or disputed by the state respondents in the affidavit in opposition filed by respondent number 1 and 2, in view of the law laid down by this court in the decision rendered in the case of Hibutama, whereby it has been held that the interstate transfer of employee can only be made between the employees who are similarly placed in the department. I am of the considered view that while transferring the petitioner from Pashigat, East Siang district to Hawaii, Anjo district as DFDO wide imbue order dated 28/2/22 issued by the Commissioner Fishery, Government of Arunachal Pradesh, white file number so and so. The petitioner could not have been replaced by the private respondent number 6, who is not a regular DFDO, but only in charge DFDO. Posted at Hawaii, Anjo district, and he has been allowed to hold the post of in charge DFDO Hawaii, Anjo district, as stopgap arrangement, and his substantial post is extension officer in the Department of Fisheries, Government of Arunachal Pradesh. In view of the above, this writ petition succeeds and the imbue order dated 28/2/22 issued by the Commissioner of Fishery, Arunachal Pradesh, so and so white file number is hereby set aside and quashed. To the extent it seeks to transfer the petitioner, Shri so and so, from Pashigat, Asian district to Anjo district as DFDO, and in his place, the private respondent number 6, Kapoti Borang, in charge DFDO Hawaii, Anjo district, has been posted as in charge DFDO Pashigat. This is one, lordship. I'll demonstrate some more judgment also. There is, that is exit. And one case is also probably pending, Your Lordship. The issue is of similar in nature. State. Your Lordship. That is yet to be adjudicated. Final decision yet to become, but the order has been stayed. Lordship, para 3, Your Lordship. In the
I've seen that.
Lordship.
You're appearing for Kivita? Okay. Yes, what do you have to say?
My lord, there very late. Petition is already read. And secondly, my lord, there petitioner has not made a party to the commissioner who has issued the Indian transfer order. His petitioner has not made a party to the person who has issued the transfer order. He has made a state and then a private respondent. For instance, there is not in general or the necessary party.
That is.
Why commissioner is a party?
So respondent number 1 itself is
One.
a party, Your Lordship.
He's the
He
commissioner.
is representing state, Your Lordship.
State, and then we're going to repeat it. Then the commissioner himself should be the party there.
No, not required. Not required. The commissioner must be, the state must be represented by someone. And it is no longer required to be made as a party by his own designation. It's not bad.
Since my lord, the order is issued by a commissioner. The commissioner should be made part, my lord.
He's there as number 1.
Number 1, yes, my lord, it is there. And my lord.
You see, it's not there. You see, it's only a designation of a commissioner. The requirement is that the state must be represented by the secretary.
Yes.
But a commissioner is also a secretary.
How many my lord will make a party to the
No,
concerned
no,
person
it's
who
not
issued the
conjoined.
transfer.
Commissioner is there.
And my lord, with regard to the my lord, this reboot of my judgment, my lord, there is a very specific observation. Because in this case, there was the availability of the regular superintendent engineer, my lord. There was availability of a regular superintendent engineer in the RW department. And honorable board to the view that since regular engineers are available, then why it should be placed by the commissioner, my lord.
This is very difficult to accept that. The reason is, if there is no post available, will somebody be appointed as what you call in charge? For example, there is no headmaster, there is a headmaster in the school, and somebody is again appointed as an in charge headmaster. Can that be done?
But if there is no post,
A
then
cadre strength is notified always. A cadre strength is notified. Only if there's a vacancy, somebody can be appointed as an in charge. There can't be an additional person outside the cadre number. Supposing let us say, in the office, there are, let us say for Oil India, there are 3 general managers. 3 general managers are already there. Can somebody be appointed a in charge general manager? In a department, let us say there are 20 assistant engineers. Can 21st person be appointed as an in charge assistant engineer? We are yet to understand that concept.
my lord, this case, my lord, there is many vacancy of the.
No, in this judgment, is it mentioned that there is what you call the cadre strength was full, and there is an additional superintending engineer in this judgment? I don't find that.
What is observed is there's no doubt of the officer as per the list, paragraph 15 madam.
Here also there is no dearth. In this case,
Yes,
is there a dearth of an engineer, executive engineer?
Yes, ma'am. But in present case, madam, there is a shortage of the regular engineers. Now, out of
No,
28, my lord.
we don't understand that concept. In this Haibutama, you show us
Yes.
that this person, additional, this in charge superintending engineer, there was no post, and he was just he was just appointed without a post.
My lord,
It can't be.
It is paragraph 59, my lord, where it's honorable observed that there's.
No, you don't go reverse. We are in a litigating, what do you call, we are examining a litigation. Please don't travel back. You travel positive. First, show us that there was no vacancy of superintending engineer, and this person who was sought to be replaced, he was an additional post. First, that must be the finding. Don't go by the judgment where it says that there are no dearth of officers. Now, let us say, let us take an example. There are 2 or 3 additional senior government advocate here. Correct. For additional senior government advocate, there is no cadre. Therefore, instead of 3, there can be 4 or 5. Correct. But there is only one advocate general. Can you have an advocate general in charge? There are no dearth of lawyers. Everyone, each one in this room is capable. Each one in this room is capable. Now, can there be just because somebody is capable? Can there be an additional advocate general? In charge advocate general? It can't. 2 constitutional posts can't be there.
But in the present case, my lord, in the department, my lord, there is a vacancy of executive engineer post. This post are only,
Please, no. Please overcome this judgment with some what do you call, some legal way to come out with this judgment. Even in this department, there are, let us say there are 5 executive engineers, and there are 25 ad hoc executive engineers. We can still read this judgment, Hibatama, by holding that amongst the 5, you transfer amongst 5.
otherwise, my lord, all this regular engineer claim that they cannot be replaced by this functional or.
So you transfer between five, all transfer should be between these five people then.
I know that it will be difficult for the department to run the matter department because if he claims that I cannot be replaced with my lord after in charge or.
No, you see, that is not a ground not to disobey the judgment of this court. Can that be a ground?
No, my lord, I'm trying to distinguish them.
You file a writ appeal. You file a writ appeal. The department can still file a writ appeal that in this case we have 30 districts. 30, how many districts now? 30? 28 districts. There are 28 districts. We have executive engineers for 22. Another 8 districts they are running with ad hoc. You see, if the state is running someone with an ad hoc, it is the state's failure. You overcome the judgment of Hibatama. We don't find any reason, any good reason.
Who is also my lord, and other specifically mentioned that the petitioner has been transferred as the executive engineer without the
No,
downgrading,
in
without
this,
affecting his
in
salary.
the Hibatama, was he downgraded? In Hibatama, was the person downgraded, petitioner? Hibatama,
No, my lord.
then,
But one was in planning matter, one was in the field matter.
oh, that we don't know.
And
There may be a superintending engineer planning, there may be a superintending engineer finance, there may be a superintending engineer MBA. We don't know.
my lord, as per this engine order, I have been transferred as the only. in
Now,
charge
now tell me,
executive engineer.
coming to this Hibatama, the person who was holding this field post, is he disqualified to hold a higher post? In the service rules, does it say that if a person of same rank is holding a field post, he will be promoted? If he is holding a non-field post, he will not be promoted. It hits Article 14. Your argument hits Article 14.
Otherwise, if you know, it says that the petitioner has been transferred as a full-fledged executive engineer at the Raga division. And here, I have been transferred only as the in charge.
No,
not as the-
Mr. Louis, you are a seasoned lawyer. Please tell me, can a person who is holding a higher post, let us say a chief engineer,
Yes.
not a chief engineer, say assistant chief engineer or additional chief engineer, can he be transferred to the post of superintending engineer? Do you think so? It can be done.
But here, my lord, I have been
No,
allowed. to
you
hold
are,
the
you are
post
making
of-
an argument. That's why I'm asking. Have you heard of any case where a man of a particular cadre is transferred to a lower cadre? Any case in the history of this Arunachal Pradesh Itanagar permanent bench? Any one case where a higher post holder is transferred to a lower post?
Maybe not here, but when I will stay, my lord, it happens.
Okay. Okay, but then we are staying it. We don't have a reason not to do, but we'll give a liberty to the state to make an order of transfer because he's completed 6 years. That is beyond his reasonable period of stay. You can transfer him with, this stay order will not come in the way to transfer him to any post vice person of the same grade.
My lord has just put a question to my brother. Suppose if a field officer transport to my lord some other place, which is not a field officer, whether it will be downgraded or not. If your lordship see the facilities they enjoy, my lord, the power they have, my lord indirectly shows, my lord, same, yes, little bit of downgrade, although.
Then I'll tell you one more interesting story. I'm good in telling those time wasting stories. This is one. If you go into the principal seat and come to my cabin, you'll find that every chair which I use is a wooden chair.
My lord.
I have a issue with my back. So my chairs are wooden chairs. Now this is a comfortable chair. is giving me a better facility here.
May I put it like this, my lord? Maybe I may be wrong, my lord, subject to your lordship. My lord, when someone is elevated to a judge, my lord, he remains in a ad hoc for the 2 years. My lord, whether he gets the same status or not, my lord.
Same.
Yes, like here also,
No, you see, there is a-
although he's in charge,
No, there
but
is a
he gets
reason for
all
that.
the facilities, my lord.
Now, please tell us, have you seen a transfer of an honorable judge who is an ad hoc judge with someone who is a permanent judge? It doesn't happen. Additional judge will go in some court. There are a lot of examples where a judge elevated in this high court has not sat here for a single day, has gone to another high court.
But I have seen, my lord, this 26 or 27 years of practice. I've seen, my lord, the portfolio judges, my lord, even seniors are not given, even what those who are elect, they are allowed to hold that portfolio judgment. That happens, my lord. Maybe some,
That is the devolution of
that
powers.
is the prerogative of the chief justice, my lord. Maybe some, I don't know exactly,
No,
my lord.
no. But you see, the issue is that when there is a transfer,
My lord.
additional judge is not transferred against a permanent judge.
No.
There normally every high court will have vacancy, they are adjusted there. At honorable judge, permanent judge, if he's transferred, he's never written in the order, he's transferred vice additional judge.
My lord.
It's not there. It's never there.
My lord.
Just come, I'll take a short break and come back. Mr. D. Loy, learned, D. Laji, L-A-J-I, learned, counsel for respondent number 2, 3. Next para. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the transfer order dated 19/9/2024 sorry, 3/9/2024
Issued on 7/9, 3/9 and issued on 7/9.
issued on 7/9/2024.
Lordship. Yes, transfer order.
As well as order dated 19/9/2024 passed by the Commissioner within bracket Urban Affairs, bracket close Government of Arunachal Pradesh, comma, by which speaking order was passed on the representation submitted by the petitioner on 10/9/2024 in compliance with the order dated 7/9/2024 passed by this court in WBC 417/2024. Next paragraph. By the transfer order dated 3/9/2024, the petitioner, who is an executive engineer, SEPA division, was transferred as executive engineer, Raga division, vice Hilang, HILLANG, Taju, TAJU, executive in charge, executive engineer in charge, Raga division, Full stop. Against the said transfer, a representation was submitted, which was disposed of by the speaking order dated 19. Nine 2024. Where is that order? Which page? 99? 99 is which page?
43. 43,
Hmm?
page 43,
43.
annexure 8. 19/9/24.
Next one. Relying on the decision of this court in Hibutama, HIBUTAMA, within bracket, sorry, comma, SE versus State of Arunachal Pradesh and another, comma, 2020, within bracket 4, bracket goes GLT 503. It is submitted that the law laid down in this case was that an executive engineer who is holding such substantive post and drawing pay of his own scale cannot replace a serving superintending engineer on transfer. Accordingly, relying on the said judgment, the present repetition in the present repetition, the transfer of petitioner against an in charge executive engineer is assailed. Next para. Issue notice returnable on, give a date after 4 weeks. Returnable also and so. Extra copy of the rate petition be served on the instructing counsel for the learned additional advocate general within 2 days. Next, the petitioner shall take steps within 2 days for service of notice on the respondent number 2 by registered post with AD. Next, heard all sides on the prayer for interim relief. Next, the learned additional advocate general has opposed the prayer for stay of the impugned transfer order on the ground that in the case of Hibutama, within bracket supra, the case is distinguishable because the First of all, in the said case, the person who was sought to be replaced was holding a field post which is not so in the present case. First, it is submitted that the petitioner is transferred to another place that is the same of the same rank of executive engineer, and therefore he cannot be aggrieved. First of the second ground of resisting the transfer order is that the petitioner has remained in the same place of posting for last 6 years. And therefore he has exceeded his normal tenure of 2 years. The third ground on which the transfer order is defended is that in the Department of Urban Affairs, there's a huge shortage of executive engineers owing to creation of newly created divisions. First of all, accordingly, by referring to the earlier order dated 22/3/2023 within bracket annexure 3, it is submitted that several executive engineers were transferred and 4 and therefore several assistant engineers were allowed to hold charge of the post of executive engineer in various divisions. Most of it is submitted that as departmental promotion committee have not been constituted to take up the issue of promotion, any order of stay would affect the performance of the Urban Development and Housing Department. Full stop. Anything more?
I have also said, my lord, since the petitioner has gained enough experience being a senior most executive engineer, now Raga being a newly created division, his expertise is required. That would be for greater public interest, my lord.
Okay. It is also submitted that the petitioner has gathered sufficient experience as an executive engineer, and therefore his expertise is required at the newly created what division?
Raga division.
RAGA Raga division. Full stop. Next, by the learned counsel for the respondent number 3 has adopted the submissions made by the learned additional advocate general. Next para. Mr. Ladi, do you have instructions? You are holding the post of executive engineer. What is your pay structure as assistant engineer? Okay,
Also in the.
you please go out and find out because that is the one of the considerations.
Lordship, as per order dated 19 September 2024, the Commissioner Urban Affairs specifically mentioned that, and whereas Engineer Hilang Taju, who is respondent number 3, though an A, was already functioning as EE Raga UD division in his own pay scale, meaning thereby.
Pay
his
scale of
pay
assistant
was-
engineer.
Yes.
Okay. Next paragraph. From the contents of the order dated 19/9/2024. It appears that the respondent number 3, though an assistant engineer, was functioning as executive engineer, Raga UD division in his own pay scale. Comma, on a query of the court, comma, the learned additional advocate general, as well as the learned counsel for the respondent number 3, would not say that whether the respondent number 3 was drawing the pay of an executive engineer. Full stop. In that event, comma, the ratio of the decision of this court in the case of Hibutama within bracket Supra is found to be squarely applicable as a transfer of unequals has been deprecated in this decision. Next paragraph. Nonetheless, comma, we find substance in the submission made by the learned additional advocate general to the effect that the petitioner has stayed in the same place of posting for last 6 years, although the normal tenure is 2 years. Next paragraph, accordingly, comma, notwithstanding that of 29/24, comma, which is produced by the learned additional advocate general, the petitioner has been released. On the post of executive engineer, comma, SEPA division. On joining in the said post by Hilang, HILLANG, Taju, bracket number 3, the court is inclined to stay the operation of the transfer order dated 3/9/2024, 1, bearing so the SUDH-11/16/UDH-UDH/57 insofar as the office serial number 2 here calling Hilang petitioner has remained in this same place of posting for 6 years. which is more than normal tenure from court is entitled to provide that this for the competent authority in the government of Andhra Pradesh, Department of Urban Affairs to transfer the petitioner against any officer of the same cadre and of the government against in charge executive engineer if such person is drawing salary of the rank of executive engineer. Full stop. Next part, the petitioner shall produce a certified copy of the order before the respondent number 1 to bring the order to the notice of the said authority. List form after 4 weeks. Return in this date after 4 weeks.
2210. My lord, I have a small supplication, my lord. Your lordship may kindly direct registry to give a copy of this order, my lord, so that will be convenient for me to communicate, my lord.
Oh, okay. The provide
2210, right?
the court master should provide a downloaded copy of this order to the additional to the general. We'll get it.
With your lord.
Also, there's a caveat discharge that you will, Mr. Raj. Your decision, take it. Yes, substitution is done. Substitution is done. You are respondent. Okay. What is the CRP for? Land dispute. This settlement in 1980 was between whom? Settlement of a land dispute in 1980 was between whom? It is on that ground that the matter was decided. In, Bilu Lombi. Who was he? Purchase. No, I'm trying to understand that this petitioners, Padam Lombi and Dami Lombi, they are inheritors of that estate. But here the names are different. Son of late Deepak Lombi and son of late Agdam Lombi. That's why I'm trying to ask. Huh? Where do you find that? Page 32. We'll adjourn it, the party is not there. Because somewhere I found that the petitioners, they are not disputing your title over that land. Only a portion. But how do you define that portion? We are not finding it. But the distinction I could not find out in the plain reading.
I don't do the trial and the systems of the margin or like the study like the village is no value.
Okay. There is no representation from the petitioners. However, Mr. D. Pangling, Learned Counsel for the respondent is present. First of all, render justice the matter stands adjourned today. List after the ensuing long vacation on a date to be fixed by the office. Yes.
My lord, the matter relates to, my lord, affidavit, counter affidavit, reading is over. Now matter has come for admission. You may kindly admit the matter because it involves certain questions. Whether the post of head teacher and headmaster of LP and my lord, upper primary and lower primary schools.
You don't want to do the hearing today?
Today, my lord, because I had the impression lordship will admit the matter.
Oh, no, for this, at least for this bench, I can tell you. Motion admission hearing orders at this stage, I can hear the matter.
That's right. And to the
You want to do it or you don't want to do it?
That lordship is absolutely right.
Huh?
Absolutely right.
Yes, you want to do it.
My lord.
Okay.
The only problem is that, my lord, yesterday, my lord, I suffered like anything, dehydration. My lord, lose
No,
motion.
that is okay. You want to do it, you don't want to do it.
My lord, today, my lord, accommodate me.
No, okay. On the prayer made by Mr. A.K. Purkar, Counsel for the petitioner, the matter stands adjourned today. Mr. T. Tagum, Learned Standing Counsel for the which department? Education Department, as well as Mr. Your name? Hey, Bhattacharya, Counsel for the private respondent is present. 15. Okay. Next part of the Learned Counsel. The petitioner submits that pleadings have been exchanged and the matter will be listed for hearing accordingly. Next para accordingly. Let a rule be issued without requiring the petitioner to take first steps. First round, leaves the matter for hearing in the week commencing 4/11/2024. The second matter is the same.
Same, my lord. In that case, my lord, I want to file an additional affidavit.
Oh. Why additional affidavit now?
Pardon, my lord?
Why additional affidavit should be
Because, my
allowed
lord, I
now?
got some, my lord, relevant reports yesterday. And these are, my lord, according to me, is
No.
very much relevant.
No, we can't permit that.
Because lordship cannot, my lord, if I pass it on, lordship cannot take judicial notice of those documents.
That's why some additional affidavit means.
You see, additional affidavit means additional pleading. You can't
No, I'm
permit
not going
that.
to, my lord, I want to bring on
No,
record
Mr.
certain.
Prakash, you see, please understand.
My lord.
Additional affidavit would mean extension of pleadings of a writ petition. We can't permit that. Either you file a reply to some affidavit or something,
Oh, some lord,
that is permissible, but we can't permit you additional affidavit
my lord.
at this
Any
stage.
affidavit, my lord, with a prayer to bring on record certain documents.
You can't have an additional pleading.
My lord.
For that, you will have to explain it to us why.
Nomenclature may be different.
Huh?
Nomenclature may be different. It may not be additional affidavit, but affidavit. Through affidavit, I want to.
Affidavit reply.
Yes.
In case of additional, leave has to be, my lord.
Oh,
It
that's
is
right.
necessary.
That's right.
That's why I made a prayer, my lord.
Reply to whose affidavit you want to?
My lord, affidavit in the sense, my lord, they have filed.
No, please, you see that if you make a prayer for additional pleadings that we are rejecting outrightly. If you want to file a reply to some affidavit, please tell us whose reply you are filing.
My lord, they have filed the affidavit of opposition and I have also filed reply affidavit. Therefore, my lord, I may be allowed to, my lord, an additional affidavit to bring on record certain documents.
No. So that only, you'll have to explain it to us. Additional pleadings will not come like that.
My lord. Now, other days also, my lord, in course of hearing, of course, my lord, I'm not saying that is the practice. I wanted to produce certain documents. Court says no, you
No,
cannot.
don't be so vague. You see, I go by the principle of Order 9, Rule 9,
Right.
Order 8, Rule 9.
Right.
If there is an additional pleading, I must understand what pleading is now sought to be brought in a writ petition of 2020.
As your lordship pleases, my lord. This is
You
my
explain to
prayer.
us. No, pleases means I am pleased with everything, good, bad, or ugly. I am pleased with
I think,
everything.
my lord, in my understanding, the documents which were supplied to me.
No, please don't
are
be vague.
relevant.
Then the prayer will be as vague as we'll be rejecting it in a very vague manner. It will be
My lord,
inconvenient for you.
the question, my lord, just for mention. Question involved, my lord, certain posts which were, my lord, created and sanctioned in favor of, my lord, Director of Elementary Education. They are returning the post. Now I got certain documents since 1986, before bifurcation. Posts are all along, my lord, related to elementary education. Therefore, in order to substantiate my contention.
No, sorry. Then we'll be rejecting that application. You see, you will have to file. Please say if the thing is incorrect. You see, now you are trying to bring in document which is a document which is pre-existing. Correct.
Pre-existing plus even
So
after
if it is
bifurcation.
pre-existing, you will have to amend your writ petition.
Exactly.
We can't permit you to bring an additional affidavit and then change the contours of the writ petition.
No, I'm not altering my pleadings. I'm just saying in support of my contention, this document may be
It just
very much
can't
valid.
come. Additional pleadings just cannot come without explaining it to us what the additional pleading would be.
That matter, of course, my lord, if there is some legal impediment, of course, I cannot.
The
But I
learned
think that-
counsel for the petitioner seeks leave of the court to file an additional affidavit. Full stop. Without anything brought on record as to what is the nature of pleadings sought to be introduced, comma, blanket leave cannot be granted to introduce pleadings. To introduce new set of pleadings or new documents. Full stop. Therefore, comma, the verbal prayer is rejected. And however, comma, this would not preclude the petitioner to file an appropriate application. Next. Matter is adjourned today, at least after 4 weeks.
No, my lord, after vacation. 4 weeks.
This after vacation, 4 weeks.
4 weeks. So then, my lord, I may be given the liberty to file appropriate application.
That's already there.
We are already given.
Obliged. Obliged.
Wait to the lordship.
Yes, Mr.
This
President.
is, my lord, regarding, my lord, grant of pension in terms of the rules framed by the government. Now, while this matter was being heard, the government said, in terms of the pension scheme, we are also supposed to give our share. Now, there was a litigation pending. It was their duty to deduct that share from our salary. They did not do that. So this honorable court wanted that I should file a reply to the affidavit,
What is that litigation? Please refer to that.
my lord.
What is that litigation which prevented them from
This
realizing?
is page 20. I'm sorry, just a moment. Page 42.
Page 22.
42, my lord, Annex
42.
7.
Page 42, yes.
So we also wanted that our pension should be in term at par with the Chief Information Commissioner. That was rejected, my lord. This is 2000, the file in 2015 was hard on 30/11/2021.
Yes.
So they were supposed to deduct our salary, but they did not do that.
Okay, from your
From our
from
salary.
through our salary.
Yes, but that was their duty, my lord. My lord, I am making a statement in court, my lord. My instructions is that we are ready to, the petitioner ready to give our share in terms of the rules. Because the rules were framed in powers conferred under the Act, so it's a part of the Act itself. So in terms of the rules, I have to be given my pension, man.
What is the date of your appointment?
Appointment, my lord. Page 20,
Just
2nd
give
of
me the date.
January 2014, man.
2nd of
January 2014, page 21.
But then new pension scheme came into force from which date?
Pension scheme is, my lord, 2014, at page 27.
20?
That is, was notified on 14th of March 2015.
14th of March
2015.
2015.
Page 27. This is, my lord, in terms of powers conferred by section 27(1), read with section 16(2) and 15(b) of the Right to Information Act. So it's a part of the Act.
No, this is the pensions, what do you call pension scheme?
Yes.
No, this is not the new pension scheme.
My lord.
This is not the new pension scheme.
No, man.
A new pension scheme came when?
This is the only scheme, man.
That is the only scheme. This central scheme of new pension scheme not implemented?
Already implemented in 2008 also. 2008.
The new pension scheme.
Yes, sir.
Is it different from this page 27?
This is for the information commissioners, man.
No, I understand. But in the entire country, this new pension scheme has stepped in.
Yes.
It overrides, the notification overrides all the other notifications. I'm just trying to understand.
This is in terms of the new pension scheme only, where we have, they will not be getting monthly pension, but a some amount. It is in
Okay,
terms of
okay,
it is in terms of that.
okay.
That is why we wanted that we should be given monthly pension, madam. That was rejected.
That was rejected.
Yes. So at least we are entitled in terms of this.
Then we have to allow this repetition. Because the pension cannot be taken away. If he's entitled by this, then you deduct it and they will make the payment.
Yeah. Pay our share, madam.
Lordship, no, Lordship, as per the new scheme, contributory pension scheme to the employees, Lordship, for this scheme, they have to contribute 10%, but that has not been done, Lordship.
That they should have done.
Was it their responsibility to force payment? The salary deduction should be automatic. Because my secretary, for example, he cannot go to the government and say that, well, I am just depositing money, take it. It is against my this pension contribution. He can't just go into the office of the accountant general and then make payment.
Lordship, because
This has to be by the drawing and disbursing officer.
And my lord,
If you can show that the petitioner has refused payment,
yes,
Lordship,
then it's a different thing.
in fact, my lord, I am submitting, my lord. Let them make the calculation, we'll pay our share. Let the government calculate.
Lordship, I'll have to take instruction for this, Lordship.
You get it, because pension can't be taken away if there's a special rule for pension. You can at best realize money from them. But this legal funding and counsel for the petitioner. Petitioners. As well as GT and additional senior government advocate for the state. Next para. The learned counsel for the petitioners has referred to the judgment dated 30/11/2021 by this court in connection with WPC 573 of 2015, by which the petitioners were not found entitled to the pensionary benefit under the old pension scheme. Full stop. Next, but it is submitted that in respect of the entitlement of petitioner to pension, the State Information Commissioner, Arunachal Pradesh, within bracket pension, bracket close rules, 2014 is in force, which is given a retrospective effect from 13/10/2006. Full stop. It is submitted that during the pendency of that the petitioner was appointed as the commissioner, State Information Commission on 2/1/2014. Post of the new pension scheme, as referred above, was notified on 14/3/2015. Post of however, from the date of the petitioner's appointment and during the pendency of the proceedings of WPC 573 of 2015, the state did not realize the contribution of the petitioner against the 2014 pension rules.
My lord, we'll see clause 18 at page 29.
Huh?
Clause 18 at page 29. They are supposed to
29.
do it from the salary.
Clause
18, my lord, serial number 18.
18.
Yes. Will be
In
deducted
terms
from
of
your
clause
salary by the
18,
TDO.
in terms of clause 18, so rule 18 of the said 2014 rules. Next, on a court query as to whether the petitioners are ready to deposit their contribution, the learned counsel for the petitioners has submitted in the affirmative and has submitted that as per instructions received by him, the petitioners are ready to make the deposit as and when such calculation is provided to them. Next, the learned additional senior government advocate submit that she is maybe given some time to obtain instructions. Next, accordingly, the court is inclined to request the additional advocate, the additional senior government advocate to obtain specific instructions as to whether the state respondents are ready and willing to accept the contribution of the petitioners towards their pension fund in terms of the 2014 pension rules. And to also indicate an estimated time frame within which the issue raised in this petition can be resolved by the respondent authorities. Next, the learned additional senior government advocate shall send a downloaded copy of this order to the who is the authorities? Respondent 3, 4, and 5. To respondents 2, 3, 4, and 5. So that the Department of Administrative Reforms, Commissioner of Finance, and the Commissioner of Personnel in the government of Arunachal Pradesh can take decision as expeditiously as possible. Next, list on after always give a date.
There is an item, part hard matter, item 17.
Obliged.
Item 17 is the part hard matter. Would you
Yes, just wait. There are a few items. We'll complete that and come back.
As you please, Miller. As you please. Can I expect around 2 o'clock or so, Miller?
2 o'clock would be better, but there's a long list.
Yes, Miller. I will be grateful.
Madam, you're also there at 2 o'clock. Yes.
Okay.
Next. Yes.
Your Lordship, this matter was in respect of a impugn order passed by the learned session Judge Khunza in criminal revision. That criminal revision was filed against 145 proceedings, Your Lordship. But Your Lordship, yesterday.
What is the original order? Where is the original order of the Deputy Commissioner?
It is at original 145 order is at page 67.
Page 60,
67, your.
67.
Yes, your.
One more, sorry.
And this order has been interfered, your lordship.
Just a moment. Yes, where is the order of the district judge?
Impugned order is at 73.
Hmm?
Impugned order is at 73, your lordship.
73.
Yes, your lordship. I'm sorry, your lordship. It's in 84.
Page?
Page 84. Your lordship.
84.
Yes, your lordship.
Is there any civil suit pending between the parties?
Pardon, your lordship.
Is any civil suit pending between the parties?
No, your lordship. That was the observation. That observation we have assailed in this petition, your lordship. The learned session judge at page number 118 held that the particular 145 proceeding is similar to that of a civil appeal, which is pending between the party in the year 1986. It hasn't been resolved. So our stand is that both the proceedings are and enclosed, your lordship, copy of civil appeal also. So your lord. Your lord. Page 37.
Just.
This is the your lord. 37, your lord.
7.
Yes, your lordship. This is the first complaint which has been filed, your lordship, by the petitioner herein against one Sri Kumkugam Singhu, your lordship. And the instant 145 proceeding is, that party is different, your lordship. In the instant 145 proceeding, it is against Indengam Singphu, Moko Jolan Singphu, the respondents are completely different. So that's our contention is that this particular proceeding cannot come in the way of this 145 proceedings, Your Lordship, because parties are different between two different sets of parties, Your Lordship. And 145 proceeding is fundamentally set only on that ground.
May I seek indulgence, Lordship? My lord, here I'm body respondent number 226, my lord. And the leading counsel is Mr. PD Nair, Lordship. I have requested me to take an adjournment, Lordship.
PCR already received.
Yes, sir.
PCR already received.
Refer record recently only.
We are unable to find the description of land anywhere.
Yes, Your Lordship, fairly submitting, Your Lordship, even in 145 proceeding, in the main complaint, no schedule is there, Your Lordship.
What is this page 41?
Page 41, Your Lordship. Page 41 is, Your Lordship, it is in connection with the complaint which is made at page 37. A meeting was held by the administration in between the two parties. So the copy of minutes of meeting is that page 41, Your Lordship.
Okay, let it come after petition.
Yes.
Who is not there, you said?
My lord,
Who is not there?
PD Nair. It's a leading counsel in it. But I responded 226, my lord.
Okay. All sides are represented. On the ground that the learned counsel holding the brief for respondent number 2 and 6 is not present, prayer for adjournment is made. Mr. G. Tado, learned APP has submitted that the TCR is also received and therefore matter can be heard. Let the matter be admitted for hearing by issuing rule returnable forthwith without requiring any press steps to be taken. Next, this is the matter for hearing in the week commencing 4/11/2024.
Your Lordship, interim order earlier.
Interim order passed earlier stands extended till the next date of listing.
Deeply opposed.
Lordship, I'm a petitioner number. I'm the
Sure.
petitioner in item
Item
number.
number 15 and
16.
16, my lord.
Yes.
Then interlocutory one, arising out of complaint case number 77 of 2019. My lord, this is a case, my lord. 482 I have filed before your lordship's court. On the last occasion, your lordships have given directions to the other side, opposite party, to file affidavit in opposition. But they didn't serve. They didn't file, possibly. My lord, this is a case, my lord. Drugs and Cosmetics Act, 1940, and rule framed thereunder, 1945. The case was the petitioners, my lord, is a manufacturer of drugs. One fine morning, a drug inspector, that means the drug inspector, surveyed the matter and took the sample of drugs. And that drugs, they sent to the laboratory for analysis this particular medicine.
Yes.
This particular medicine, my lord.
You see,
They-
this is page 24. It says that the drug does not comply with the Indian pharmacopoeia.
Yes, rightly pointed out. My lord, kindly come, kindly, kindly comes to the
Where is the second report? Did you ask for?
first
the
report, my lord,
examination?
is annexed P3. It is
Page.
annexed P3, first
Page.
report. The sample, bottom portions of this very particular annexed 3, my lord.
Page.
Kindly comes.
Give me the page.
Page 24.
24, yes.
Page 24, annexed 3.
Hmm.
The reasons of declaring the sample as not standard quality.
Correct.
They say. But it is very much curious that once laboratory has already been passed this very particular analyzed order, but page 29 kindly comes to page 29, annexure 8. It is annexure 7. Annexure
Yes.
8, my lord.
Yes.
This is regional drug testing laboratory. Guwahati. Their opinion is different because in the bottom portions of this very particular annexure 8, page 29, my lord. In the opinion of the undersigned, the sample referred to above is of standard quality as defined the Drugs and Cosmetics Act 1940 and rules that frame under. The sample confirms claim with respect to the test purpose.
Where is the
My
seizure?
lord.
Where is the document of seizure?
Documents of seizure, my lord. No seizure, my lord.
No
They
seizure.
filed complaint 200.
But then
Only
tell us-
collected samples.
No, but then tell us.
But it is the duty of the drug inspector to file the said drugs and within 60 days. Within 60 days. But they didn't. After lapse of 24 days extra, that means the 98 days,
Please
they filed the.
Please respond to the court query. You see, this first report at page 24
Page 24, my lord.
is Inspector's Memorandum of 27/3/2017.
My lord,
Correct.
date of
Now this-
testing report, my lord.
Unless you allow me to complete, you won't understand what I'm asking.
My lord.
Correct. Now, page 29, you showed us
Page 29.
Yes. In this page 29,
Page 29.
this was sent by whom?
Under central government.
Under central government.
By the central government?
Yeah.
Both under central.
Both
No.
under central.
By the Inspector of Drugs Kachar.
Yes, my lord.
Yes, state government.
Inspector of Drugs Kachar. Who has sent this page 24?
24, G. Narendra Kumar.
G. Narendra Kumar. G. Narendra Kumar, drug inspector. Is appointed by the central government.
Correct. So this is.
But,
you
but
see-
he did not.
You see, that's why the question I'm asking. Number one, page 24 is sent by G. Narendra Kumar, Drug Inspector,
Yes.
CDSCO East Zone,
Yes.
Central
Calcutta.
Standard Fund.
That reserved is that report that was sent on 28,
28
27
March
3,
2017.
27 3 it was sent, 28 it was received.
Yes, yes.
And this report came on 6/7.
Issued on 6/7/2000.
Correct. Now come to page 29.
After 29.
Page 29.
Page 29.
Date of receipt
Date of
from the
receipt.
drug inspector is 6/9/2017.
Date of receipt.
So it's a
6/9/2017.
it's a different sample altogether.
Yeah. In the opinion of
So
the
the
under-
second, if the second sample is of
Same
standard
sample,
quality-
Your Lord.
no. You see, samples are differently sent. It is, we don't know which batch it is. Is it from the same batch?
Yes, my lord.
Yes, madam, same batch.
How do you show us that? Show us that.
Can you see that? Page number
No,
29?
three of you don't argue. One of you will.
It's appearing on 15. I don't know 15. I'm 16. Both are
Just
interlocutory
one
matters.
by one by one. Just tell one by one.
Oh,
Le-
that's same content.
Where do we find that?
Given in the report itself.
Page 25 is the report. Batch number is SCT 601.
601.
Second sample,
601.
where do you find that? Show us.
Batch number 601.
That-
Column 5.
Column 5.
Serial number 5.
Serial number 5.
Serial number?
5.
Page?
24.
Page 24.
Acha, batch number LOT SCT 601. Then there has to be the what you call. Yes, what is your prayer in this criminal petition? What is your prayer in the criminal petition?
Yeah, Miller. To quashing the complaint of my lord, page 18, my lord. Kindly comes to page 18. It is clearly stated. This honorable court be pleased to issue notice and admit the present petition.
Yes, yes, sir.
Page 18 and 19 both. This is the prior portions, which is clearly stated. This honorable court be pleased to call for the records of criminal case number 7719.
But you see, there's another point. Number one, the Central Drug Testing Laboratory at Calcutta gave a report. That report is not set aside.
Yes.
So how can on the basis of the report of Assam, we can set aside a prosecution for a spurious drug?
These the questionable matters. After lapse of 60 days, testing report submitted, 98 days. Rule 45, my lord, against the prevailing rules of the Drugs and Cosmetics Act
You just
and
wait for a
rules.
time, wait for some
45.
Wait for some time because I have a matter fixed at 2 for hearing. We'll take it up that first. If time permits, then we hear this matter. We'll,
My lord, your lordship is a, yes, my lord, deciding possibility.
no, it will take some time. Just wait for some time. There's a matter in, through remote VC. We'll have to do it. Then we'll come back.
But kindly note down one matter, my lord. May I submit? The other side, that man. After some time, my lord, it will.
If time
But
permits.
other side did not, still now submitted the affidavit in opposition. Kindly note this.
We'll see that.
After some time. Good. Two more.
Yes, item 17.
Item number 17.
Lordship, this is pertaining to item number 8, whereby I'm the
Yes.
petitioner. And then item number 17, respondent number 2. I would like to say something to the court. I will not take much of your time,
Item
just
8.
2 minutes.
Item 8.
I don't want to waste the time of the court.
Yes.
My lord, I appeal before your lordship to respectfully inform that the court that I filed a formal transfer petition in the Supreme Court, citing instances of clear and present bias exhibited by your lordship both during the hearing and outside the courtroom. I was prejudged and character assassinated by your lordship, even without hearing me. So it is prayed your lordship will keep all matters in abeyance until the Honorable Supreme Court decides the matter. I complained and
You should have got a order of stay. A mere pendency of a transfer petition will not come in the way of the court to decide the
today is
matter.
Monday. Lordship, today is Monday, and my legal team is currently filing the complaint now, and they are currently filing the complaint. It's Monday, and the events that occurred, I do not have. It was the weekend. The courts are closed.
You want to make any submission in item 8?
Lordship, I have filed since both the matters are listed together, I have filed a complaint against your lordship for being biased in the Supreme Court.
Okay.
So you may kindly
In
keep the
item,
matter.
item 8, in item you say petitioner in person has does not want to move the matter before this bench. Full stop. Accordingly, the matter stands adjourned today. List. Before any other bench without. Just say list after a week.
My lord, is it still part heard?
Now, item number 17, what do you have to say?
My lord, both the matters is regarding both the matters, my lord. As I started, both item number 8 and
You want to make any submissions?
No, my lord, is regarding this matter, both the matters, my lord.
I have to make some submission.
My lord, I just wanted to take 2 minutes of your time to say that I have filed for a transfer petition to the Supreme Court and complained regarding the bias nature which was shown to me by your lordship.
Okay.
I'd like to make a submission.
Yes, Mr. Rowdy.
Rather two submission. An affidavit was filed, if I am right, on Friday or Saturday. And this affidavit is not in compliance with the order of 14 March 2024, because an affidavit was directed to the extent the order, if your lordship had seen that order of 14 March, kindly see minute, that is the only affidavit which was required to be filed. and they had avoided or they had not adhered to the
Lordship, if I may interrupt,
Please.
my lawyers are not present today. I have come personally myself. My lordship, we are not arguing the matter.
Please don't interrupt. Senior counsel is making a submission.
Yes,
You wait for your turn. We'll give you a turn for reply.
Let kindly see
Yes.
14 March order, which I had placed before you the other day also, Millard. And in the middle of the paragraph, your lordship will see the last 4 lines. Mr. D. Verma, that the signature of Namchum is available in the said application, which he has compared with the specimen signature, which is available at an HRA, was not so appended by Namchum, but is alleged to have been forced by the petitioner herein. Mr. D. Verma has further submitted, this is the crucial part, at an HRA and B were received by him from the case diary after the trial court had passed order granting liberty to the learned counsel representing the respondent number 2 to take such copies from the case diary. The above matter required further consideration and accordingly, the respondent number 2 is required to place on record by way of an affidavit the order passed by the learned trial court by which the aforesaid leave was granted to the respondent number 2 to take extracts or make copies from the case diary of the matter. Now, this is the affidavit which was directed by the Scott Millard, and the affidavit which they had filed. Of course, I do not know how it is entertainable under a criminal law, Millard, in criminal jurisprudence. If there is a direction by the court, yes, you have to file. This they had not done. And what affidavit they had filed? In this, they are enlarging. First affidavit, after 155, 156 of the CRPC, Millard, there is no scope of any affidavit. But what they have done through the whatever this 50 pages affidavit is, they are incorporating now the new sections 3Q, 3ZA, etc., and whatever the original FAR or complaint was there, Millard, wherever these sections or this kind of allegation or abetments were not there, they are now incorporating it. So this is my first submission, twin submission. A, the affidavit directed on 14 March had not been filed. They are avoiding it. After that, as I told you the other day, they have taken 6 adjournments for filing the affidavit. Number 1. Number 2, as I told you, the present affidavit, through an affidavit in a criminal procedure or in criminal jurisprudence, you cannot enlarge the scope of whatever your FIR or complaint was there. So this affidavit, which they had filed 2 days back, Millard, just need to be ignored totally, Millard. Now, my third submission is, according to, if your lordship will kindly come to page 78, which is the second FIR. Second FIR starts, Millard, on page 77 and it concludes on page 81. But I want to draw your lordship's attention to a very focused part of this FIR, page 78. Kindly see the 2 paragraphs. The first paragraph, if your lordship has that. First paragraph of page 78. Today at about 14:10, I was informed by my office that Anil Ahoti, along with the father Rajendra, on fraudulently and illegally sent an email account so-and-so without my consent or knowledge to the board of directors of Chogam So and Veneer Mill, which is a company of which my daughter and me are 58% majority shareholder. Kindly mark, they are the majority shareholder number 1, and they are in the possession of the entire unit from February 2021. Now, this is important. They are majority shareholder. It is not a case of minority shareholder of operation, etc., etc. And kindly see the next, which is more pertinent than the first. This criminal act was perpetrated by the aforesaid serial criminals, was holding a shareholders meeting to inform my daughter, Sunita Namchum, and another person is director in my company. The objective of the criminal so-and-so was to play fraud not only on me, but also on registrar of the companies into making them believe that I have resigned from my own so-and-so, so-and-so. Now, kindly mark, Millard, and take a note, under the Companies Act, there are specific provisions, Millard, Section 206, Section 212, and Section 448.
kindly keep a note, my lord, of the three pertinent sections. 206, my lord, obliges, and I'm placing that before you, my lord. Power to call for information, inspect books, and conduct inquiries. My submission is there is a special provisions under the Companies Act from 206 to 210 as to whenever any fraud or any kind of misinformation is given, the ROC, the Registrar of Company, is obliged and empowered to do the needful from 206 to 210. So 206, the caption is power to call for information, inspect books, and conduct inquiries. That is 206. And 207, conduct of inspection and inquiry. And then the most important is 212, Millard. 212 says, in 212, the section, subsection 6, kindly similar. It says, if a company, I'm sorry, 206.6 first.
Companies Act.
I'm sorry, my lord is not having the vote.
Yes, please continue.
Yes. I was drawing your attention by placing 206.6. If a company fails to furnish any information or explanation or produce any document required under the section, the company and every officer of the company who is in default shall be punishable with fine which may extend to 1 lakh so and so, so and so. So the punishment is also provided in 206.6 for after inspection of the books and inquiries. And thereafter, as I said, kindly see 212, also subsection 6. There also, how the inquiry is to be conducted, investigation is to be carried out, everything is contemplated and stipulated. My short summarized submission on this point is very much simple, that when there is a special provision and when on page 78 they are saying, and I reiterate and request your lordship to record that sentence, the objective of the criminals was to play fraud not only on me but ROC. If there is any ROC fraud, Millard, then the provision of the Companies Act, which is a special statute, and 206 to 210 is the entire hierarchy of the scheme as to how ROC is supposed to proceed, Millard. And then, of course,
Companies Act. Yes.
So that was my third submission of the day, Millard. And then kindly see, Millard, one of the last submission, what is the status of inquiry today? The FIR, lordship recollect, is 3.5 years old. Now, it is not that whether I had undergone, I was in the custody or not. The question if the entire punishment ultimately is of fine under sections 418 and 423. The ultimate sentence can be maximum 2 years or 3 years, and minimum sentence is fine only. Then why do I have to face the rigorous of a criminal proceedings, Millard? Mental harassment and physical and all those things which I need not have to tell you, Millard. Your lordship carry the required experience. So 3.5 years, and the other day, the learned APP suggested or probably placed that they had conveyed to Google's. I would like to know in 3.5 years period from FIR till today, when Google was informed, whether it was followed with the Google, what is the response of the Google? You cannot just convey or claim to have conveyed to Google and then hold on the two petitioner for long. This will also be atrocious, as the Supreme Court had said, Millard, in the two judgments, Millard. One judgment which I will be placing first, Millard, this same very bench of Bhajanlal, Millard. Now kindly take a note of this judgment, Millard, if your lordship won't mind. 1990, volume 2 SCC, page 340.
Name of the parties?
State of Andhra Pradesh versus PB Pavitran. And this Justice Ravindran Ratnavil Pandian Millard sitting with Judge Chandra Reddy. And they had Millard, I will be placing before you only the 3 or 4 paragraphs of page 343. The High Court has questioned, I am para 4 to para 7. The High Court had questioned the first information report on the ground that there was inordinate delay in the investigation. Agreed by the judgment, the state has preferred this criminal appeal. Mr. So-and-so, learned single counsel appearing on behalf of the appellant took an exception to the observation of the learned single judge of the High Court. I hold that whenever there is an inordinate delay on the part of the investigating agency in completing investigation, the case merits quashing of the first information report. Kindly mark completing inordinate delay in completing the investigation. Generally, this court will not quash the FIR because it amounts to stopping of the investigation, but where there is an inordinate delay, the same is ground to quash even the FIR. And in paragraph 7, the Lordship says this, Millard, there is no denying of the fact that the lethargic and electrical manner of investigation over a prolonged period makes an accused in a criminal proceeding to live every moment under extreme emotional and mental stress and strain and to remain always under a fear psychosis. Therefore, it is imperative if the investigation of a criminal proceeding staggers on a tardy pace due to indolence or inefficiency of the investigating agency, causing unreasonable and substantial delay, resulting in grave prejudice or disadvantage to the accused. The court, as the protector of the right and personal liberty of the citizen, will step in and resort to the drastic remedy, Millard. Now, this, and I would again, with your permission, would place one paragraph of Bhajan Lal again, Millard. Because your Lordship had seen, Bhajan Lal have been reiterated, reaffirmed of more than half a dozen judgments, including the judgment which we had shown of Justice M.R. Shah the other day, which in the compilation page 40 is there, Niharika, Millard. Niharika was placed by my learned opposite party also, respondent number 1. Here on page 42, Millard, for your convenience, if your Lordship sees what the Supreme Court in Bhajan Lal had said is extracted, and I am reading from page 42. Then comes the celebrated decision of this court in the case of Bhajan Lal. In the same decision, the court considered in detail the scope of the High Court powers under Section 482 CRPC or 226 of the Constitution of India to quash the FIR and refer to several judicial precedents and held that the High Court should not embark upon an inquiry into the merits and demerits of the allegation and quash the proceeding without allowing the investigating agency to complete its task. At the same time, this court identified following cases in which FIR complaint can be quashed. Now, my learned friend was reading respondent number 1, only the first part, that the High Court should be cautious in quashing under 482 and FIR, but M.R. Shah says this. At the same time, this court identified the following cases in which FIR complaint can be quashed. Number 1, and kindly mark, Millard, if you take out SC/ST, both the offenses are non-cognizable, bailable, and trial by any magistrate. Now, kindly see 1021 and 2, where the allegation made in the first information report on the complaint, even if they are taken at their face value and accepted as their entirety, do not prima facie constitute any offense. Now, and then 2, where the allegation in the first information report and other material, if any, accompany the FIR do not disclose a cognizable offense, justifying the investigation. So your Lordship will say, will kindly appreciate, in my case, when there is no cognizable offense, in the sense that 148 and
218.
I'm sorry, Millard, sorry, give me a moment.
23.
One, I'm sorry, Millard. 148 and 423. These both sections are, kindly note down, Millard. 418 and 423 both
My
are
lordship,
both are
my lordship, I would like to
both are
interrupt.
non-cognizable.
My lordship,
And as I
my
said,
lordship,
You'll get your time, you'll get your time.
my
Let
lordship,
let the
the
senior
last,
counsel complete.
the last time also, it's clearly biased, the last time also.
Let-
Only the
let
senior counsel was given the chance and I didn't get any chance. Today I have presented before the
I'm
lordship
continuing.
saying the
So,
matter,
418
I have
and
applied for a,
423.
transfer petition in the
We have heard
Supreme
you.
Court
We
with a
have heard you, and now we
complaint
are hearing
about
the
your,
senior counsel.
with a complaint about your lordship.
We have heard you.
Say you're biased. So today my lawyers are not present. So
We have
how
heard
can,
you. We are now
how
hearing
can
the senior
you,
counsel.
how can you,
Please,
lordship,
please,
you are hearing
please
only
do not
the,
disturb.
this is clearly
Please do not
biased.
disturb the senior counsel.
Lordship,
We have heard you. We have taken note of your statement. That
lordship,
you do
but
not want
still,
to,
in
that
lordship,
you don't want the matter to
lordship,
be
he
heard
is
before
only
this
given
bench.
chance. Yes, lordship. So
So
because only he is
400
being given a chance,
We have heard you.
clear and patent, and I biased by the, after I have informed you, you're still giving him a chance to speak and to argue about the matter. My lawyers are not present here. I have come personally, none
We
of
have
them
heard
are
you.
within lordship.
We have heard you.
But
Please
you're
don't disturb the
listening to
senior
the
counsel.
senior counsel. Yes.
Please do not disturb the
my-
senior counsel.
So my respectful submission was both 418 and 423 Millard are non-cognizable, bailable, and triable by any magistrate. And now after 3.5 years, whether the public prosecutor is justified, Millard, under the criminal jurisprudence.
That is, Mr. Dowdy, we have told you that day also.
No, I may not be-
Mere length of pendency before this court would not entitle to a quashing.
No, Millard,
Or yes, on
kindly
merit,
appreciate-
it's okay, but
No, Millard, kindly
It's a-
appreciate the harassment and the agony which is going to.
that is okay.
Now,
Harassment, harassment
finally,
is something else. It's beyond our
Yes,
scope right now.
yes, finally, Millard, as I told you, that affidavit which was required and mandated by 14 March 2024 has not been filed, Millard. So these are my respectful submission
Yes.
that and 31P, kindly appreciate. And now the other day, the learned PP was talking about 31R. Where is the 31R in either of the FIR, which are both of February and April 2021? There is only of SC/ST Act reference is given to 31P, Millard. And as I had demonstrated before you, and hopefully successfully, that it is a business dispute. Repeatedly, they are referring, even if you read the first FIR or the second FIR. And if a business dispute is there, no criminal jurisprudence can be invoked. And if the special statute of the Companies Act is there, if according to them, whatever I had claimed to have filed before the ROC, they are all fraudulent or misstatement, let the ROC should exercise the divine jurisdiction under the Companies Act. These are my respective submission.
Okay. Yes, you have to say anything more?
Yes, my lordship. Let me present to you. I am the one who is being harassed here. With the protection given to the accused, they have been filing fake complaints against me, criminal cases against me, and calling me accused. And what is the rush in this matter? It is 3 years they have been given protection. So what is the rush? The senior counsel, ML Lahoti, wants, what is the rush? They are in protection, they're enjoying the freedom. While I am, my lord, I am the one who is being harassed here. I'm a single tribal lady. They are going to the local jurisdiction, roaming around freely without any conditions. They have been given bail and protection by the court. They have been given protection by the court without any conditions. They are roaming around freely. They are filing complaints, fake complaints against me, which the authorities have not admitted. But that is, I'm the one who is being harassed here, my lord. And I have complained formally for transfer because I will not get justice in this court.
Okay.
My lawyers are presently in the Supreme Court. So, Lordship, you may keep the matter in abeyance till the matter is decided.
pursuant to order dated 19/9/2024, the matter was adjourned and listed as a parted matter on 23, today, i.e. 23/9/2024. Next para. The petitioner in person, the respondent number 2 has appeared in person and has expressed her dissatisfaction with the bench for taking up the matter. It is submitted that agreed by this particular bench of this court, the respondent number 2 has moved the Supreme Court of India for transfer of these proceedings. Full stop. On being asked as to whether she would exercise the right to reply in this matter, the respondent number 2 has refused to make her submissions as she has moved to the Supreme Court of India for transfer. Full stop. Next para. The submissions in reply against the submissions made by the learned APP on 19/9/2024 has been made by Mr. M. Lauti, learned senior counsel, through RBC, assisted by Mr. R. Dubey, learned counsel. Next para. This being a parted matter, as the proceedings before this court has not been stayed, the hearing is concluded. Full stop. Order reserved.
My lord, I have not
Lordship,
reported my submission.
Lordship, you may please add my lawyers were not present today. Lordship,
The submission which I made
Lordship.
today, kindly record.
Yes, you have recorded it.
Lordship, you may add that my lawyers have not made a submission today.
I just
Have
add one
not
more
been
line.
heard,
Add one more line.
have not been heard today.
Although the counsel for the respondent number 2 on record has not appeared, but the petitioner, but the respondent number 2 is accusing the court of not hearing her learned counsel. Full stop. It may be stated that one of the counsel on record for the respondent number 2 has already accused from the case, which is reflected in the order dated 23. Sorry, this is 19/9/2024, and the other counsel on record has not appeared either physically or for request for remote video conference. Full stop. Same order.
Grateful, my lord.
Obliged.
Yes. Drugs and Cosmetics Act.
Rule 45 of the.
There's a rules also.
Yes, yes.
Yes, I said no. Rules we have, drugs crime, right?
Rule 45. It clearly shows section 45.
Yes.
The government analyst shall cause to be analyzed or tested such samples of drugs as may be sent to him by inspector or other persons under the provision of chapter 4 of the Act, and shall furnish reports of the result of test of or analysis in accordance with these rules within a period of 60 days of the receipt of sample. Here, my lord, my case is very much clear. After lapse of time, after lapse of statutory period, that means after lapse of 60 days, 98 days, they serve the copy, serve the analyzed copy. Test report. This is the test. Page 24, Annexure 3. Page 24, Annexure 3. Which is more
Time limit is how much? 60 days.
60 days. My lord.
This, how many days delay you said? How many days it took for the report?
98 days.
98. Yes.
My next submissions before your lordship's court, it is very much clear that your petitioner state that they have been residing at a place beyond the area in which the learned magistrate exercises jurisdiction. There must be an inquiry under section 202 of the Code of Procedure 1973. The chapter 15 deals with the procedure to be followed by the learned magistrate upon taking cognizance of an offense upon the complainant. Here, my lord, the learned magistrate took cognizance under section 190 CRPC and did not examine the complainant.
Not
That
he is exempted.
Yes, my lord.
Drug inspector is a official, he is exempted.
Subsequently, my lord, your petitioner states that section 202 CRPC was amended in the year 2005 by the Code of Criminal Procedure of the Criminal Procedure Amended Act 2005 with effect from 26 June 2006 by adding the words and shall in a case where the accused is residing at a place beyond the area in which he exercises his jurisdiction. There is a vital purpose or objective behind this amendment, namely to ward off false complaints against such persons residing at far off places.
Read 200, read section 200. In 200, there is an exemption.
Yes.
Public servant in discharge of official duty is exempted.
Exempted. Oath like this oath is exempted. Oath is exempted.
No, examination is exempted.
No, 202 is not exempted.
202 is not exempted.
You see 200.
202.
200.
No, 202 will come after 200. Examination of the complainant.
No, my lord.
No.
202 is mandatory.
No, please, two of you don't speak. Two of you don't speak.
202, my lord, is mandatory. But without 202, the learned magistrate issued process under section 204. That is totally arbitrary and illegal. That is totally arbitrary. Even, my lord, when the two reports are different, it's a crucial matter. Two reports are different. There is a questionable mark, my lord. One judgment, my lord, I am submitting before Lordship's Court. This particular judgment, my lord, 2015 12 Supreme Court cases 420.
2000?
kindly comes to this particular judgment, my lord. Para 22. Para 22. 30 of the particular judgment. Para 22. This is a Supreme Court judgment, Supreme Court cases. Yes.
Just a moment.
Para 22.
Just a moment.
2015-12 Supreme Court cases 420. Page number, my lord, 430, paragraph 22.
With decision?
Yes. 2015-12 Supreme Court cases.
Paragraph?
Paragraph 22, page 430, in our page 430. Here, the steps taken by the magistrate here, the steps taken by the magistrate under section 190 clause 1A of CRPC, followed by the section 2204 CRPC, should reflect that the magistrate that applies his mind. That is only the first question. Whether the particular magistrate has applied on that particular point of time, applied his mind? No. Answer is nil. And the statement and is satisfied. That is a ground for proceedings further in the matter by asking the persons against whom the violation of law is alleged. Here the particular inspector submitted the analyzed report or analysis 98 days beyond statutory period. 60 days is permissible under the law. Drugs and Tax and Cosmetics Act 1940 and rules 1945. They violated. While it comes to 22, your lordship easily acquainted with the facts, circumstances, what is going on at that, what was going on at that point of time.
Yes.
Here, the steps taken by the magistrate under section 191 plus A CRPC followed by section 204 CRPC should reflect that the magistrate that applies his mind to the facts and the statements and is satisfied that there is ground for proceeding further in the matter by asking the persons against whom the violation law is.
This submission is made in respect of which part of your prayer?
Which?
Your submissions you are making is in respect of which part of the prayer?
When the কথাগুলো লিখে বলা ছিল বলা হয়নি। কত গ্রাউন্ড বলুন? Page 13 রাখুন। kindly comes to page 13 of my application for 80.
13.
13. Here, the grounds, first, for that, the criminal
No, no,
complaint
grounds
case-
can be many things, but I am on the prayer. Which part of the prayer you are directing these submissions? You have not asked for questioning of the order of issuance of process.
prayer portion, I have stated in the prayer portion everything.
That's okay, but
This is the prayer portion. Quashing, 482 application stands for quashing.
This-
482 stands for quashing of the complaint. Yes. To paragraph number 8, that it is most respectfully prayed as under. This honorable court be pleased to issue notice and admit the present petition. This honorable court be pleased to call for the records of criminal complaint case number 7719 pending before the court of the chief judicial magistrate.
It's come.
Janapur,
Records have come.
Arunachal Pradesh,
records are
along
there.
with the summons.
Records are there.
The pending of hearing and final.
You only told us that the records are there. I did not check it. Record है? Trial court record. Trial court record.
And after examining the same, be pleased to quash and set aside. My lord, page 19, it is stated clear. Page 19.
In this case, the records are not called. This first file is before me is 115. Second. In second case also, we are not called for the records.
Page 18 of the prayer portion B. Page number 19.
No, you never made a prayer to call for the records. Records have not come. You never asked for calling the records. This prayer was never made.
My lord, prayer B. This honorable
No.
court be
Prayer in the writ petition or in the criminal petition, there will be hundreds of prayer. But you did not ask for the calling of the record. There is no judicial order to call for the records. Let's see. Just wait, there's some confusion. This is judicial order to call for the records. Please check out. Is it an order of? I don't find. Please check up. I may be missing it.
But in the cause list,
No,
item,
I don't know the cause list.
item number
I-
40,
No,
it
the
is
cause is
on.
not there and this. Please check up the records.
Sorry, item number 50.
Section of proceeds. Section of proceeds. Just wait for some time. We'll ask for this section because there is a note that the LCR is available in the cause list, but there is no judicial order and it's not there in the record. Please check up the office note. I did not check up. I don't think in the office note also there is any entry that records are received. And the note sheet also is not there. Note sheet I did not check. Note sheet also is not there.
Office note is also not.
Just wait for 5 minutes. Let him, he's gone to section. He's come. No, the section is not there. You want the records to be called? No. Then proceed. So then. Okay. If you want to proceed, you can proceed. If you want that the records be called, then you can have to adjourn the matter. You want to proceed?
Let it be fixed after 1 month.
No. Time will be after. I am giving you two things. Number one, if you want to proceed in the matter, you can proceed. If you want that the records is required, then we have to call for the records.
Record is not required. Record is not required. Record is not required.
Okay. Then please proceed.
Section 20. Section, my lord, the Drugs and Cosmetics Act 1940.
Yes.
Section 25, clause 4. Section 25, clause 4. That is only the evidentiary matter elucidate one by one the wrongful act of the respondents. First of all, my lord.
Section
25, clause 4 of the Drugs and Cosmetics Act 1940 is a old act, but this is very much clear, my case, for proceedings of 480. Unless the sample has already been tested or analyzed in the Central Drugs Laboratory, where a person has under subsection 3 notified his intention of adduce evidence in contravention of a government analyst report, the court may, of its own motion, that is only the vital matter, court may, of its own motion or in its discretion at the request either of the complainant or the accused, cause the sample of the drug for cosmetic produced before the magistrate under subsection 4 of section 23 to be sent for the produced before the magistrate under subsection 4 of section 23 of this sent for produced before the magistrate for test or analysis to the said laboratory, which shall make the test or analysis and report in writing signed by or under the authority of the director of Central Drugs Laboratory, the result thereof, and such report shall be conclusive evidence of the facts and stated therein. This is a conclusive evidence. Even, my lord, if your lordship comes into the section 23 of the Drugs and Cosmetics Act, section 23, plus 4, 4 Roman 2. Reading boiling. 4 Roman 2. That was not some.
Yes.
Roman 2. The second he shall produce to the court before which proceedings, if any, are instituted in respect of the drugs or court message. And a third is very, that is the most important point here. Section 23, procedure of the inspectors. They violated the norms, they violated rules and regulations of the cosmetic rules and drugs already, and they kept mum about these particular matters. And I'm harassing day by day. And a manufacturer. One judgment, my lord. Medipol Pharmaceutical India Private Limited versus Postgraduate Institute of Medical. 5th August, which is 20. This particular judgment, my lord, paragraph, para 9.
What is the citation?
Para 9.
What is the
Citations,
citation?
Citations. Hold it. Citations. Medical submission to be na. Para 9 tadi. Ito para 9. The Laboratory Pharmaceutical India Limited versus State of Tamil Nadu, 2018, volume 15, SCC 1993. After referring section 25 of this act, this court held as follows. The most important judgment here, section 25, clause 4 of the drugs and cosmetic tools. Another judgment is in another judgment is 2008. 2008, volume 7, SCC 199, 96, para 6. That's a copy.
In this judgment, you are referring to paragraph 9.
Yes.
Which paragraph you are relying?
Paragraph 9.
9.
9. Another judgment I am cited before your lordship court. 2008, volume 7, SCC 199, 96, para 6. Para 6. My next submissions, my lord, and coming one by one. Section 34 of the Drugs and Cosmetics Act 1940. Here the offenses by companies. Section 34. Section 34. The Drugs and
Section
Cosmetics.
30, you're taking us to section 30. Just a moment.
Section 30.
Just a moment. Yes, 30.
Section 34. Offenses by companies. Where an offense under this act has been committed by a company, every person who at the time the offense was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly, provided that nothing contained in this subsection shall render any such persons liable to any punishment provided in this act if he proves that the offense was committed without his knowledge, or that he exercised all due diligence to prevent the commission of such offense. In the complaint case, the respondent, Union of India, they did not highlighted this very particular section 34. That means the offense of the companies. It is most vital for adjudication of the particular case, whether the particular innocent person has been prosecuted or not. A deliberate game on the part of the Union of India, the inspector, and falsely implicated into the matter. Another judgment, my lord, I am submitting before the Lordship's court for the purpose of proper adjudication of this matter, so that conceivable justice may be done by the petitioner in good faith. Paragraph 15 and 16, Prem, Pharmaceutical and others versus State of Madhya Pradesh and Port Mail. Paragraph 15 and 16. Paragraph 15 and 16.
Paragraph
15 and 16. Lord,
Yes.
this brings us to the last contention as to the liability of the petitioner, 2 to 11. The explanation appended to the section 34 of the Act provides that for the purpose of this section, company includes a firm and director in relation to a firm, means a partner in the firm. We are not concerned with the proviso to subsection 1 of the section, and without it, the said subsection and subsection 2 reads as under 34(1), where an offense under this Act has been committed by a company, every person who at the time of the offense was committed was in charge of and was responsible of the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. As section 16, paragraph 16, my lord, in Ramakrishna Bharati's case, it has been held that vicarious liability, that is the vicarious liability, is an independent incidence of an offense under the Act, as pointed out in the Municipal Corporation of Delhi versus Delhi Rajasthan, this Raj 1985 criminal. It is only on fulfillment of specified conditions that a partner may be liable. In the instant case, it has now here been stated that any of the partners at the relevant time was in charge of and responsible to the company for the conduct of its business, and thus in the absence of allegations which constitutes precondition for fashioning vicarious liability on the partners, they cannot be held liable for the offense of in questions. That is only the vital matter. Your pure questions of intricate questions of law is involved here. And this judgment has been cited, another judgment, citation, 1998 Criminal Law Journal 2165, paragraph number 212. This is more vital. Paragraph number 12. Paragraph. Para 12.
With all respect to the judgment, how do you overcome the bar of section 9 of the Partnership Act?
At the initial point of time, when the drug inspector inspected the matter, took collections of the samples
Please look at section 9.
particular strips
Please
of
look
the
at section 9, then you'll. Please look at section 9. Just show it here.
section 9, you can't think about it. Section 9.
I thought it's not misspelled. It's 16. Indian partnership. It's a part number. Section 16 of the Act of Indian Partnership.
See section 9 and section 12. How do you come out of that?
Indian Partnership Act.
This is Indian Partnership Act.
All partners.
Here
Section 9 and section 12, how do you overcome that?
general duty of the partners. The company is incorporated under the Companies Act 1956.
I understand, but you say
Yeah.
partner. You said that you are a partner. You're a director or a partner?
All are the directors.
Okay. Oh, then it is not required. I
All
thought
right.
that you were saying that you were a partner.
My lord. Para 12 of the one judgment,
Yes.
I have already submitted before your lordship said, Mehta and Company, another was the state of Rajasthan, another. On
Yes.
15 January 1989, it was published. Paragraph 12. Paragraph 12. After considering the arguments of both the learned counsels and going through the case law cited by the learned counsel for the petitioner, I am of the opinion that the learned trial court has committed error in issuing process against the partners of the firms who are not in charge of the business of the firms or conducting its affairs when the offense is alleged to have been committed only the persons who was in charge would be proceeded against, and therefore the prosecution of the petitioner and issue of process for this offense against them is bad in law, so it cannot be maintained. That is the argument.
Yes. You wanted to submit?
Item number. Adapting the total submission of the only want to add one. As per draft rules, it was stated.
You're in item number?
15.
One 16. Yes.
As per draft, it was stated that if a product, if the sentence is repeated, the word is important that repeatedly it should be. Thereafter, one officer can file any complaint. Number one. And number two, finally see the conduct.
Where is the repeated failure?
Yeah, Lordship, I am saying, another point, Lordship.
No, which provision?
Yes, I'm going there. First, see the conduct of the other side, Lordship. The matter was filed in 2019, Lordship. From then, we have the Lordship, what are we doing, Lordship? Item number 114. Finally, come to page number. Seventy-nine.
Yes.
Order of the learned citizens.
79. 79.
Yes, 79.
114.
Item number 114.
114 is 79 is a part of petition, I think.
79 of the petition. Question petition.
Yes, yes.
Page number 114. 79.
Check this.
114, please. 114. One one five.
Yes,
Page number 79, Lordship.
yes.
The last paragraph. Learned counsel for the complainant has said that he may be given time to file withdrawal application on the next date. It's 1/3/2023. Lordship, the matter was filed in 2019. And kindly see the last order, Lordship, honor of the 23rd, 12th, 2023. Kindly see the order of honorable courts of
Which order?
23rd, 12th, 2023.
Twenty-three twelve. 2312. There's no order of 2312.
Yes, yes. Last time.
Okay, what is the point you are trying to make?
Actually, see the conduct of the other side, Lordship. They are unnecessarily dragging the matter only. Only they are dragging the matter. They are not appearing properly. They are only dragging the matter. Actually, we are coming from Kolkata. Lordship, the company, all the directors are senior citizens. All are more than 60 years old. There is nothing else. Only the other side want to harass the company. Nothing else. See the conduct of the company.
How will I see that? You see, that's something which I can't know. I don't have personal knowledge. You'll have to tell us what is the conduct.
No, Lordship, see the conduct because affidavit direction was there. Till today, nothing was given. Can you see the opposition? Can you see the conduct of the opposition?
No, what conduct you are referring to? Please tell us the conduct, then we'll understand.
That's why we are asking for quashing the Lordship. Because
In
due to
Quashing,
that-
you are making a prayer before the court. What is to do with that, their conduct?
Lordship, what happened last 4 years, the matter is pending regularly. We are coming.
Oh, it
from
may be
Kolkata.
10 years also. I have taken up out of turn. This is not for hearing today. Don't make those allegations. We take strong objection to it. You want it for hearing, we send it. Even after spending so much of time.
No,
No, don't get those allegations.
Lordship, kindly see.
You see, we saw
No, no,
you,
what-
we
what
are
I'm saying
taking up the
was-
matter.
what I'm
And now you are
saying-
referring to a conduct.
No, Lordship,
Then my
what
conduct
I'm
is also
saying-
questionable.
What I am saying that they are dragging the
No, no.
matter. I want
Today-
to just explain.
Please see, today is not a good day. There is one allegation about my conduct, matter has gone to Supreme Court. Now again, you are referring to a conduct which touches upon me. Why I did not hear?
I am not.
No, no, no.
alleging-
We don't-
My
we don't
allegation
hear.
is the other side, Lordship.
He will hear the matter. He can only assist me when I am doing the hearing.
Lordship, it's my submission.
No, no,
because
no.
Where
We take an
we
exception
are-
of everything.
They are dragging.
We have the patience to hear everything, but not.
Kindly see this.
Okay, we'll fix it for hearing. If you want a date for hearing, we fix a date for hearing. Don't blame the conduct of the council.
No, I am not saying
No, no.
what of the council. I am saying that.
You see,
conduct.
that submission,
no,
no, Mr. Council, please understand. That statement of yours has hit the court very badly.
No, no, no.
It's
Lordship,
almost it's almost
I
a
am paying
affronting to the court.
unconditional apology, Lordship.
No, no.
I am paying unconditional apology, Lordship.
For 3 years, it could not be heard.
But what I am saying, actually,
No, no, after hearing the matter for so long, if I have to hear that, why this matter has not been heard.
No,
it's
no,
very
no, no,
unfortunate.
Lordship, I am not saying that. Lordship, you misunderstood, Lordship. Kindly,
Please,
kindly say
I-
one thing. I am saying unconditional apology. I have
I
not
have-
said that.
I have understood
I-
it.
No, I
have
have
understood it.
Lordship, what I should just give you
Please
one
don't,
chance, Lordship.
please
For my
don't.
satisfaction, Lordship, just one thing. I don't want to, I
No,
am saying
what-
unconditional
you-
apology.
No, no, just tell me, in the conduct of hearing, what is the role of the respondent or the petitioner? Lawyer of the petitioner or lawyer of the respondent?
I am saying what.
Now,
Lordship,
please tell
there
me,
was a
in your
litigation-
career as a lawyer, have you not taken any adjournment till this age?
Yes, I have taken.
Then-
But it's, the matter is.
Then you
pending
don't
from
touch upon your
2019.
conduct.
Why I am saying, Lordship, the matter
No, please,
was
that's
filed
over.
in
We fix it for
2019.
hearing. We fix it for hearing, you fix a date. You give a
No,
date, fixed date.
Lordship,
for
kindly,
hearing.
we are coming from Kolkata, Lordship, kindly fix it.
We don't know we were hearing you. At the last moment, you made me upset. I have
No, no,
forgotten
no,
everything you have heard.
Lordship. I am paying unconditional apology.
No, that's
My
okay,
senior-
but in this, you
My
see,
senior
when I,
status, I am paying unconditional apology,
you
Lordship.
see, when you make that statement, you have upset me so much that I have forgotten what you have argued.
I said, Lordship.
But I have forgotten. I am not taking up. Why the matter has not been heard? If I have to give explanation, we'll take the matter. I have taken up the matter for hearing out of turn. It's not fixed for hearing. I am taking it up. And then you say about the conduct of them.
No, I am not saying that, Lordship.
No.
I was trying to say.
One
conduct
finger
of-
pointed out here, three fingers point out at me.
Conduct of him, I have not
Hmm.
said. I am saying the conduct of the drug inspector, Lordship.
So drug inspector will come here and assist me in the hearing. But don't tell all these things. Don't tell all these things. I am hearing the matter. I am hearing it so patiently. And then again, you have upset me.
Lordship, kindly, paying
No, it's okay.
unconditional apology, Lordship.
No, I have taken but I am adjourning it. I have accepted the apology. I don't carry it forward. I
No.
don't keep dead bodies in my head.
Lordship, that petitioner are all
No.
more than 60 years old. They are regularly.
No, no. Item 15 and 16. The matter was, the counsel for the petitioner was heard for some time. Although the matter is in the admission column and not at the hearing stage. Full stop. The delay in the hearing was referred to by the learned counsel for the petitioner. Full stop. Therefore, the hearing done so far appears to have not been appreciated by the learned counsel for the petitioner. Full stop. Therefore, notwithstanding that the matter was heard at length, the court is inclined to adjourn the matter and admit the matter for hearing by issuing rule returnable forthwith without requiring any fresh steps to be taken. Full stop. The respondents are represented by Mr. M. Kato, learned. You are appearing at DSGI.
Yes.
As DSGI and Mr.
El Rakap.
L. Tagam for respondent number.
No, I mean,
Achha, with you, along with so. Full stop. Let the matter be listed for hearing on. You want a date, take a date. Which date you want to come? You give a date of your choice. Which date you want to come?
December.
Tell a date, we'll fix on that day. Take a date of your convenience.
December.
Take a date. There's a calendar, please.
13.
1/3. Okay, 1/3/12/2024 as a fixed matter.
13 December.
13 December as a fixed matter.
I am dead.
Interim order passed and stands extended to the next date of this thing. Yes.
But I'll get.
Yes, Mr. Nevo.
My lord, this petition was challenged, filed, challenging the legality and validity of the order passed by the deputy commissioner,
Yes.
revenue officer.
But you know, incidentally, what caught my eye in this case is that the petitioner is residing opposite Art of Living.
Yes,
And after residing in the neighborhood of Art of Living, you are in court. That is something which I found very surprising.
and
You don't attend that course.
my lord,
Petitioner is only a neighbor, but he doesn't attend the course.
is the lane matter dispute is of the other side of the road. Art of
No,
Living
I
has
understand.
their,
I am
has
understand.
their
I
all
understand.
concrete buildings, schools, everything is there.
Incidentally, there is a judicial order in Rajasthan High Court by our former Chief Justice, Justice Mehta, sending a person to a particular mediator in the Art of Living. And it was very successful. The person before whom this mediation course, meditation course was sent to,
Yes, my lord.
I know personally because she's a wife of an honorable judge. And it was so successful that this course was introduced by Honorable Justice Sandeep Mehtaji in almost all the jails. And a particular class of people were by judicial order asked to under that course, and the result, I'm told, by the I met the lady, the former, the wife of the honorable judge in the Rajasthan High Court, that all the cases were successful.
My lord, the impact is
The-
very good.
The crave
They-
of these people to fight, to have intoxication, to
Yes, my lord.
everything is
They
settled.
open
And
conduct.
Rajasthan, unlike people from this region, are more tough because of that.
They
their
open conduct
environment.
yoga and meditation. So we also participate some in some
Participated. Okay.
on some occasions.
That's why I just remembered. Yes, now what has happened to the land dispute?
My lord, the
This is
petitioner.
an order of eviction.
It is in page number 47, my lord.
Yes.
My lord, here before passing this order, there was a dispute between earlier the complaint made by one respondent number 6. It was going on in the beginning, and after proceeding for 3-4 proceeding, it was converted. The title, the verses was changed. Though the petitioner was same, it was changed to Art of Living, and thereafter deputy commissioner has summoned for 2 occasions, and at the third stage, the deputy commissioner has altogether decided the case, and that also not in the name of this Art of Living deputy commissioner, but deputy commissioner come revenue officer, which was never happened.
Where-
That is why no
Where is the
notice was
order? Where is the order? Impugned?
in the earlier order, my lord.
No, the order impugned in this.
Impugned order is,
petition,
my lord, page number 47, my lord.
40.
47, 47.
Yes. Yes.
So this was passed on the same day without giving an opportunity, without giving opportunity of submitting the grievances before the authority. Why the revenue officer come, deputy commissioner come, revenue officer. And earlier that the deputy commissioner has already summoned in this case in two occasions. One occasion they summoned and other occasion had gone for the verification. That the
I did not
authority has
get it.
changed it
I
the
did
same.
not get it. Please repeat again. I did not get it. Please repeat again.
My lord, in this was the case. Initially, this case was characterized as Navungeja versus Bengetolo. Bengetolo, I am the Bengetolo. And then, after proceeding for 4 or 5 occasions, it has changed. On the, again, another complaint was given by Navungeja, and another complaint was given by Art of Living on 17th. Was given on.
You are saying that the case proceeded for some time. Then after that, it was changed to something else.
First, it was Navungeja versus Bengetolo. Then it was changed to Art of Living versus Bengetolo. And that is the first complaint. The case was proceeded, my lord. Case was first proceeded on the basis of complaint made by Srimati Navungeja, which is in, my lord, and it is in page 34. Please peruse.
34.
34. And page number 34. On the basis of the complaint made on 25/1/2021. And thereafter, order was passed under 145 CRPC. Read with.
No. It doesn't take us anywhere. You come to page 47. You are referring to page 47.
Yes,
Please come
yes.
there. See the first line. The complaint was submitted by number so and so dated 5/2/2021. Now, where is that document?
Yes, that is in that complaint is on page 41. 41.
41. No, that is something is wrong somewhere. You see,
My lord.
this complaint at page order 47 page is what proceeding? Is a eviction proceeding by the LPC, right?
Page number 47.
Page 47 is an eviction matter.
It's
right?
a.
Please hear us.
Okay, my lord.
Page 47 is an eviction matter from land which is occupied, which is covered by an LPC, right? You are showing us page 41. Come to page 41.
41 is a complaint
No,
made
you are
by.
showing us, I am just reading it. See the reference, case number so and so under 145 CRPC, dated 8/2/2021. So 145 proceeding and the eviction proceeding under the LPC land are two different proceedings.
Yes.
You say that one proceeding is converted into another.
No, it is different.
Then
But
please don't confuse us. I am already confused. man.
Yes, my lord. Sorry.
No. Please know your facts pretty well.
Mm.
You were showing us page 34. Then we found out the fault in page 34. Then you take us to page 41. 41 is unrelated. So are you aware of your case?
The
Or
petitioner.
hear the other side.
The petitioner is now the petitioner has changed. Yes, my lord.
No. Then we cannot hear you. Petitioner has been changed. Is 145 proceeding and eviction case. You say that petitioner is changed.
First, it was Navungeja, and second, it is Art of Living in charge
complaint made by Art of Living in
So
Church.
but today is not a good day for us. At least for bench, I am saying, not a very good day.
Yes,
Please
my lord.
don't make submissions which are apparently not correct.
Okay, my lord.
You
I'll
say,
try my best.
you say page 47, the petitioner, the name of the party is changed thrice. I asked you to show us that. Then you take us to page 34 first.
Yes.
In 34, it's by somebody else. And this complaint is 25/1/2021. Then we ask you to come back to page 47. It does not refer to this complaint of 25/1/2021.
Yes.
Then you tell us, come to page 41.
Yes.
Page 41 is a 145 proceeding.
On this basis, the impugn order is passed.
Don't tell us. Don't tell us. On the basis of 145, an LPC eviction case will be taken up.
My lord, I'll try my best. My lord, this page.
I don't know. Yes, please assist us.
Your Lordship,
Mr. Nivo, we have heard you. Please sit down. Your case, we'll hear it from her.
Your Lordship, I'm appearing for respondent number 2.
Huh.
The last occasion, the petitioner counsel, he has sought adjournment for filing of rejoinder.
Oh, forget the rejoinder. We close that rejoinder part. Now, what is the case of the petitioner?
Yes, Your Lordship. Your Lordship, this.
No, don't tell it from your perspective.
Yes, sir.
Tell us the petitioner's case.
Yes. Your Lordship, the petitioner, he is an encroacher of the land occupied by the land possessed by the Art of Living. That is private respondent number 5.
Yes.
And this proceeding, annexure 3 of our annexure, our counter affidavit, Your Lordship.
Annexure 3.
Yes, 3 series, Your Lordship, page 31, Your Lordship.
Page 31.
Page 31.
Yes.
Has been initiated after the complaint.
No, that is second part. It's a post pillar erected.
Yes, Your Lordship.
So,
This,
you see, we are not on that. We are first one to understand. Is it right that the petitioner's case at the order at page 41 of the writ petition, 47 of the writ petition? Is this a proceeding which is converted from some other proceeding to this proceeding?
no, Your Lordship, this proceeding is proceeding has been taken under the Land Settlement Records Act, Your Lordship.
Land Settlement Act.
Yes, Your Lordship. If Your Lordship may come kindly.
Land Settlement Act.
Come to page number 37 of our affidavit, Your Lordship. Page number 37.
Now, Mr. Nivo, somewhere I read here, just a moment. I read somewhere here that when you asked for the documents, you were given everything, including the GPS coordinates and Google Map. Correct? Now, where is that Google Map which was given to you, showing the land in question?
My lord, it is at page number 58 of my writ petition.
58.
Annexure E series. Under E series, all the documents which has been issued by the Deputy Commissioner on the date of the final decision of the impugn order.
I think through Advocate General, I must congratulate the state. Through the Advocate General, I have to congratulate, or sorry, appreciate, a word of appreciation for the Deputy Commissioner ICC Itanagar, T. Potom. Look at the order. I really appreciate. Give a copy to the Advocate General.
Yes, sir. Please go. Please go.
Such appreciation from the court is always a great thing.
No, but really,
Wait.
it's a long order. Page
Your lordship is
47.
referring to?
Page 47.
Page 47. No, no.
47
Of the writ petition.
Of the writ petition.
I'll just omit here and there and then go fast. Huh? Just the only relevant part which is for you.
Your lordship is referring to which part of
Page 40, I'll tell you. Page 47, please skip to page 49.
49? I'm on
Yes.
49.
Yes. On 49, you come to paragraph 4.
That in the year
2011 after total formalities and verification of the documents. Correct. 5. Learned Counsel submitted satellite images of the month of March 2012. Correct. Now this is examined. 6. So-and-so submitted satellite image of the month of February 2013 of so-and-so, so-and-so. Next, after 5 or 6 lines, 20 number of pillar by geotag coordination number so-and-so. Still available. Then next, Council submitted a satellite image for the month of October 2014 of so-and-so, so-and-so. Next, 8. Learned Council submitted satellite map of so-and-so. There are many things here. I'm omitting it. I'm just showing you the technical part of it. The Learned Council submitted para 9 satellite images of the month of February 17. 10. Satellite image of month of December 2019. Then this COVID para 11. Then 12 part of it it can be omitted. Now 53. in the middle, after that signature.
What?
After heard in length, so and so. Now he's transposing all these satellite images and now arriving at a finding that there's an encroachment. Just wonderful. Not a fault.
Yes, put in a lot of effort.
Put in a lot of effort. What happens to the order, we don't know. We may still strike it down.
In fact,
But
I must inform your lordship, since your lordship is on this deputy commissioner. Very recently, only last week, we were having this issue regarding where the new judges' bungalow should be located. Honorable Chief Justice was here, and the registrar called me up to say, "Sir, we need a little bit of help from you. While the Honorable Chief Justice is here, we'd like to visit one or two locations, and the Honorable Chief Justice wants to have a look." And we had to arrange everything in a hurry. I called up the Honorable Chief Minister, and he immediately responded by saying the right person would be this man. He directed me to him, and he himself, the Honorable Chief Minister, gave a call to this Deputy Commissioner, and he promptly took care of all the issues. And that on the administrative side, your lordship will get the feedback. And things have really moved since then. He is known to be a pretty efficient officer.
I don't know, but this is something I should appreciate. I thought that since you were there, as the Advocate General, I should tell you that at least I record my.
I'm grateful. I'm extremely grateful.
I should express my.
And I will convey it to him.
Yes, but Mr. Nibo, in the process, unfortunately I can read very fast. So these are the pages I have already read, and we don't find any fault in this order. The arrival of a satisfaction that there was an encroachment is not only based on the geosatellite images. They are expressly referred to by coordinates, and then it comes with a finding with the satellite map that there was an encroachment of a house in a particular place in that map. That's why I wanted that map. In the map, there is a disclosure. One of the maps, there is a disclosure that there is a house, and that is the encroached portion on the. If you see the map here, it will be in my left side. So that encroachment is shown. Yes.
Just for the maps, Lordship, I am respondent number 5, the art of living. In page, Lordship, page 41 onwards are the maps,
Okay.
which I had given to the Deputy Commissioner.
Okay.
This is starting from April 2005.
I don't know, but one shows a house. I won't remember which one.
That is the last one, Lordship. That is of January 2022, which he has annexed at page 58 in his petition. But the other maps he has not annexed. The other maps I have annexed.
Okay.
This is showing, because this is Lordship annexed due to the reason that they have stated in their reply that they had been living there since long time. So this is to show
Yes,
that
this is
since
current encroachment structure 01 Bengia Talo. Bengia Talo is the petitioner.
yes. Yes. In my affidavit.
So, Mr. Nibo, we can't interfere. This order is valid. You have to. If this otherwise legally can be passed, we can't interfere with this order.
We have painstakingly given every image since 2005 just to show that the encroachment started only in the year 2020.
So the appreciation must go to you also.
Yes.
Oh, very good. Very good. Very technical. In fact, this is the first time I've seen like this, anything like this.
Lordship may see page 41 onwards, respondent number 5's affidavit.
41.
Onwards. We have submitted year by year, just to show
Mr.
that.
Nibo?
It's only in the last, in the last page, the encroachment is shown. That is of January 2022.
So, Mr. Nibo, one failure to make me understand has gone into this technical aspect.
My lord,
Now you please try to find fault with this order. How do you show that this is false? Number one, your first submission that the proceedings was a conversion from a different proceeding to another proceeding. That is, that submission is not acceptable.
Okay.
Second is with regard to the merit of the order. Is the eviction order permissible under 2000 Act? Does he have jurisdiction to pass orders?
My lord, may I submit?
Huh.
This, firstly, I would like to, just 2 points only in this regard. Otherwise, my lord has may pass any other order. Firstly, in the time of passing this order, that in the very day order has been passed, and after passing the order, all the documents, relevant documents, whatever has been annexed in the annexure E-series has been supplied with the orders. That was the as Deputy Commissioner come, Revenue Officer. Secondly, what I want to say that this order is not the eviction order. As per my opinion, my submission, this is not a eviction order, simple eviction order. This is a final decision order. That is number 2. Number 3, the
This is
land
a
matter,
This is
land
a final, I did not get it. This is a final.
final order, the final order in the matter of land dispute between 2 private individuals. So number 3, what I would like to submit is that
No, please
Deputy-
elaborate, I did not get it. Final order,
this is a final judgment and order passed by the Deputy Commissioner in the land dispute
yes,
of 2 private individuals.
yes,
Thirdly, what I would like to submit is that
yes.
in the private land, between 2 private land, Deputy Commissioner or the Deputy Commissioner cum Revenue Officer has no authority to interfere between the private disputed land. It is for the civil court. And so therefore, the Deputy Commissioner cum Revenue Officer has no civil court authority. And regarding the land dispute, only the civil court has the authority to pass any such final judgment and order. So in this regard, the 2000 section 123 of Land Settlement Record Act 2012 clearly says only civil court has the authority. He might have passed very detailed orders, but he has no authority to interfere in the private land to decide the land as who is right and who is not right and whose titles, who should hold the post. So till 145 or 133 is okay, but the final judgment or settlement or decision or declaration cannot be made by the Deputy Commissioner or Revenue Officer. It is for the civil court. This is my.
Okay, this is the best argument.
This is
the best argument.
this is and is furthermore, my lord, if permit, I would like to submit that.
Yes.
My lord, one more thing is here. Here it shows that the art of living has the LPC. LPC is based on the gift deed issued by given by respondent number 6 and 7. In this regard, also I would like to submit a few.
That part of your argument is not acceptable. You are wanting to say that the gift deed has only one signature, the other party did not sign it, right?
No, apart from that, that is on the gift deed.
Hmm.
Apart from that, as per my understanding, the art of living is for the Arunachal Pradesh Land Settlement Record Act 2012.
Yes.
This is regarding the jurisdiction of my civil court. And regarding LPC, obtaining of LPC for non-APST, it is made clear at page number 20, at section number, it is at eligibility of allotment of land. Regarding this, as for the Arunachal Pradesh Land Settlement and Record Act Rules 2012, it is made so to be eligible, a person who is a citizen of India and an indigenous of Arunachal Pradesh civil tribe
APST shall be eligible for allotment of land in urban and rural areas. So in this regard, I
Unfortunately,
I feel
unfortunately-
not appropriate that the non-APST.
Unfortunately, that argument I can't hear. Because that is, this petition is not to challenge the LPC.
Yes, of
So
course, I
therefore-
made the prayer, but
No, this is not a
I
petition
basically
to
I'm
challenge the
challenging the
LPC.
order only. Basically, I'm
Yes, where
challenging
is the
that.
power under land management, Mr. Kamduk? Where is the power under this act to adjudicate eviction?
This is my lord, in the capacity of revenue officer, my lord. He is the.
Where, which section?
That, my lord. Well, find in section 82, my lord.
Section 82.
Yes, ma'am.
No, that is where an order is passed, that is use of force, but where is the power to pass order? This is use of force under 82.
My lord, section 79, my lord.
79.
Yes, my lord. Appeals and revision, it says, my lord.
'79 is also not there. Please read 79. 79 doesn't take us anywhere. A revenue officer, while exercising power under this act or any other law for the time being in force to inquire into or decide the question arising out of determination between government and any person.
Yes.
This is not what you are doing. Art of living is a government I did not know. In the state, the art of living is a government I did not know.
Privately.
Yes. My lord,
No.
it's clearly private.
Yes, sir. So where is the power? Where is the devolution of power in this act?
That power, my lord, appointment of revenue officer, my lord, is there, my lord. I'm trying to find it out. My lord.
No, but revenue officer is not entitled under the land laws to order eviction. Which section?
My lord, appointment of revenue officer is.
Which section
four,
you are
my lord.
reading? You are reading which section?
Section 4, my lord.
1.
4, section
4,
4.
4, 4.
Yes, my lord.
Yes, section 4.
Appointment of revenue officers, my lord.
Yes.
Whether government or such. Officer
That is appointment of revenue officer.
May appoint the following classes of revenue officer, namely deputy revenue commissioner, ex officer, or deputy commissioner. So, my lord.
The source of power to order eviction is not there in this act.
Specifically, it is not mentioned, my lord. But from the plain reading of my lord, section 79 and 82, my lord.
No. 79 and 82 can't empower.
Deputy commissioner, being the revenue officer.
Jurisdiction in a law must be vested. There can't be a presumption of an authority. Jurisdiction must be statutorily vested. There can't be a presumption of authority to evict. 82 is where there is any order passed under this act. 79 says government.
Yes.
If none of the parties are government,
My lord, it also says, my lord, and any person or between parties to any proceeding. It says in my lord, 79 my lord.
Between the government and any person or between parties to any proceeding. Shall be a revenue court, and when trials and disputes will be guided by the principles of so and so. A revenue officer, while exercising power under this act or any law for the timing in force, to inquire and to decide question arising or determination between the government. And any person, between the government is, suppose is two persons,
Yes, my lord.
between is for
Between
two persons.
two individuals.
No,
my lord.
no. You see, the first word is determination between the government. Between, and which the word envisages two parties.
And
Now, between the government and any person or between parties to any proceedings. Between government and person or between parties to any proceeding. So this covers private disputes also. You're trying to say that.
Yes, my lord. So my understanding, my lord, when
Shall
it
be a
says,
revenue
my
court
lord,
when deciding such
between
disputes.
the
shall be-
government and any person, after that, my lord, this, or between parties to any proceeding. So to my understanding, my lord,
No, then you are leading to a dangerous proposition. You just now read section 4.
section 4, my lord, it is regarding
Yes.
appointment of revenue officers, my lord.
Yes, so revenue officer, even a mandal is a revenue officer,
Yes, as per,
chainman is a revenue officer.
yes, as per this act, my lord.
So whoever, when a revenue officer, 79 says, exercising power under the act. So even a mandal can now order eviction. Chainman. Section 4 says chainman. Chainman is a person who just measures.
Yes, my lord.
He can't be a revenue officer to decide eviction.
My lord, for more clear position, my lord.
Oh, I have to rise. I have to rise. We have to continue some other day.
My lord, section 6 is gives the power.
Section 6. No, we need a special power empowerment for eviction. There must be some empowerment for eviction. Every court is has the power to do certain things. It must clearly say that it empowers eviction.
My lord.
You find out the provision, we'll take it up day after tomorrow.
79(2), my lord. It says, my lord, noting that this act shall be deemed to limit or otherwise affect the inherent power of the revenue court to make such
Correct.
orders as may be necessary for the aims of justice.
Correct.
So, my
Can
lord,
this also be read that he can tomorrow order hanging to death? Sentence revenue court, there must be some power which is circumscribed. It can't be unlimited power. Now the revenue officer chairman comes and says, no, we don't want a chief minister. I will evict him and now I become the chief minister tomorrow. Unlimited power. You can't have those unforeseeable things being done by a chairman, revenue mandal.
as per this act, my lord, there is no, this provision for eviction. is
No,
not
I understand, but there must be
my lord,
some
violated.
empowerment. There must be provision for empowerment. What class of case he will take up? You see, section 9 in the CPC says that all residual powers are taken up. Unless expressly barred. So it comes to civil court. But is it in force in the state of, Arunachal Pradesh? Is this act in force?
Yes.
You have mutation orders. I've never seen one. I always find LPC coming to court.
LPC, my lord, even in this act, my lord, how to this issue LPC is not provided, my lord. Okay, there is a just memorandum guideline
No,
of the.
but please tell us, when this act refers to the power of the revenue officers for demarcation, for maintaining records, for ordering mutation, how do you reconcile this with the power, unlimited power of the revenue authorities in issuing an LPC without such inquiry? We'll hear day after tomorrow. I have to raise. There's a division bench commencing now.
May I pray for a little indulgence? Item number 36.
You just tell the postmaster because I have to write. There's a division bench at 4:20.
It may be fixed on 30th of October.
Just tell him. We'll accommodate. Just Advocate General's matter. There's a division bench at. There's a division bench right now, where I'm giving a judgment which is very hugely lengthy, 500 paragraphs.
Most obliged.
Item number 1.
In first set of writ petition, there are 12 matters. Are you getting my voice?
Yes, yes, sir. Yes.
In first matter is a matter of 12 cases, which what do you call, which are sorry, this is the second item is 12. First item is 257. We are passing a separate order. In the first item 257.
Lordship.
The order of attachment as confirmed dated 11/11/2011 and 29/12/2011 are interfered with and they are set aside, and accordingly the properties are directed to be restored to the persons from whom they were seized, which shall be done after preparing a detailed inventory. The second is a set of cases with criminal appeal 165 of 2016. To criminal appeal 145 of 2017, which is item 13. So these are 12 matters. In respect of one matter, which is N. Bomi Singh, there is already a judicial order that the case is abated, appeal has abated, and therefore that matter is already excluded, being abated. And in all of the matters, we allow these appeals and the appellants are acquitted of all charges. And those appellants who have not yet been released shall be released forthwith if not wanted in any other case. Accordingly, the registry shall issue the release orders on production of which the concerned superintendent of jail, where the appellants are presently lodged, shall do the needful. The order is running to 226 pages and it is 534 paragraphs.
Big exercise.
Thank you. Yes,
Lordship, it's a big exercise.
no, big, I won't say, it will be voluminous.
Lordship.
But it was a learning experience to be with esteemed brother Justice Kalita, who has given valuable inputs to make this happen.
Lordship.
Thank you.
Lordship.
It will be uploaded by after some time because it's a lot of volume. It is taking some time to convert into a template for being released. So I think by tomorrow it will be done. We are trying our best to do it today, but I think it will be uploaded only tomorrow.
Lordship.
Because there is a procedure, I am told, the small orders, they can do it in very fast. But since it is voluminous, it has to be converted from the Word into the template for uploading it into the system. So
Lordship.
that is a process which is taking time here.
Lordship.
Thank you.
Okay.